I already mentioned before your lordship on Monday, lordship, but it's not appearing in the list. Difficulties, lordship.
On Monday itself, I have said that it will appear part by part. I cannot put all the matters in the list together. It will appear.
Lordship, matter is fixed. Learned court below, lordship. Tomorrow, lordship.
Give the number once more.
File lies in courtroom number 10, lordship.
I am mentioning, my lord.
কালকে একটু দিয়ে দেবেন দিদি।
One matter, my lord, which now this is item number 297. My lord, no problem. Urgent matter, my lord. It will take 5 minutes time.
What is your urgency, sir?
Urgency, my lord, trial court is not granting any time. Because
For what?
my lord, the court says unless we bring the stay order from the honorable court, it will proceed.
So which order is under challenge before this court?
My lord, we have given letter, but my lord, practically court says,
What order are you challenging before this
my
court?
lord, amendment of the plaint at the initial stage. And that too, my lord, partition suit here was wrongly written. Court below has said, no, I will not allow. My lord, it will take 5 minutes time. My lord, I assure you, lordship.
Have you put the other side on notice?
Yes, yes.
Give
Yes.
the number.
My lord,
Madam, may I have your lordship's kind?
For what?
Removal of unauthorized.
Please, group 1 matters, please wait.
Madam, may I have lordship's kind?
Let me deal with court number 19. Then I'll take up your matters.
May I have lordship's kind?
Court number 19, please.
Madam, may I have your lordship's kind leave to mention a matter, madam? This is in respect of a suit for account wherein an order to a rule 6 application has been dismissed. Against that we have come to Bengali businessmen, madam. They are losing.
What is your urgency?
When urgency is there, madam, we are losing lakhs each day. There is a categorical admission in the written
Have you
statement.
put the other side on
Yes,
notice?
I have put it.
My lord, may I permission to mention a matter. My lord, this matter, my lord, in a partition suit, the other side admitted that I am the 50% owner. Even I have made an application under Order 12, Rule 6. The court has rejected, hard, considered, rejected. Now, my lord has put the matter for framing of issue on 16 January. Now, my lord, unnecessarily the matter will be, is 2016 matter, the matter will go for 5 more years. Now, my lord, my urgency is only to consider my petition on merit, my lord, only that, my lord.
Have you put the other side on
My lord,
notice?
this admission stage, my lord, there is no caveat, my lord. I'm grateful, my lord.
Extension of entry order. Upon notice?
May your lordship permit me to mention, the matter is urgent. The matter is pending in the trial court in the
What is your urgency, sir?
for more than a year. My lord has been pleased to my lord has been pleased to come to today. I have mentioned the matter earlier, but my lord has been pleased to ask me to come today. I have already served.
Number 19 matter.
Court number 19 matter.
Yes, yes, my
CO.
lord. Yes, yes.
Urgency. Matter.
Madam.
Child court is not urgent. That
My lord, the trial court is not giving any time. It has been fixed.
Sir, you can wait till 22nd. This is not urgent.
My lord,
Two matters which are imminently urgent.
my lord, may I
The matter is so urgent because yesterday the landed trial court refused to accept my examination in chief and directed me to file fresh within 2 hours, and thereafter lordship imposed pause and fixed the matter on lordship 11. So lordship, on this lordship urgent circumstances also I am paying your lordship leave to lordship file without certified copy, lordship. Only to file, lordship. I am not.
Which order are you challenging?
The examination chief filed for the lordship landed trial court lordship by the defendant
Yes.
was returned and directed to lordship file afresh on the ground that the WS was not correlated with the lordship examination in chief, and directed to file that within 2 hours. I am adding the lordship copy of the order lordship and received lordship within 2 hours, and for non-compliance lordship 200 cost has been imposed and fixed the matter on 11th lordship.
11 for what?
11 lordship to file the lordship file the examination in chief
So
as per WS.
what is your urgency?
Urgency to lordship file without certified copy. I have applied
You
this.
have been given opportunity to file your examination in chief on the next
I have filed. I have
on the
filed
next
that.
date.
That was not accepted, lordship.
You have another date has been given for filing
But
of
lordship,
examination in chief.
the grounds lordship which has been lordship hold for rejection lordship that as per WS it was not filed. Certain evidence that was disclosed, which was not accepted by the landed trial court, which is lordship required for adjudication. It is not beyond the lordship pleadings.
Be granted.
My lord, yesterday I mentioned your lordship, my lord.
Number 9.
Without certificate. For filing without certificate.
My lord, the
I mentioned your lordship, my lord, the date will be short notice, 92 years, maybe my lord.
my lord,
Item number 1238. On residential.
Yes, I cannot follow you, yes? It's not urgent, sir. You can wait till 22nd. Wait, there are several matters of 2009. No, there is no urgency, sir. I'm sorry. But yes, maybe all the matters pertaining to senior citizens. You can wait till the 22nd. No, it's not urgent, sir. I'm sorry. You can wait till the 22nd.
my lord, the matter is appearing in the monthly list of court number 19, my lord.
It's a contested hearing matter.
Motion stage, this is motion stage,
Yes.
I am, my lord, I am for the plaintiff, my evidence has to store. I have mentioned, your lordship, I give notice
Hearing
to outside.
My lord, the matter is appearing in the monthly list of court number 19, my lord. There is a caveat I have served upon them. My lord, the urgency is 16th is the date fixed in the lower court, my lord. For the evidence of defendant, my rejection, the trial court has rejected my petition for the recalling of PW1, my lord. This is a 2014 suit, my lord.
Do you really think this is urgent? Can't wait till
My lord,
22nd?
this is 2014 multiplicity.
Starts, will you be affected? Your application can still be considered, isn't it? Wait till the 22nd, sir.
My lord, this is a 2014 suit, my lord. It will not take much time.
I have rejected a 2009 matter.
My lord, the revision will be
22nd. Matters which can wait till 22nd, please do not mention. Please do not mention.
Lordship, may I have Milord's kind leave to mention a matter? The bank has obtained an order from under section 14 of the SARPC Act by playing fraud upon the magistrate by suppressing that the civil division is before my lord has obtained an order of injunction from the civil court stating that the property that is the subject matter of the dispute, the status quo shall not be changed. The police officers are now coming to my property and seeking steps for my eviction, my lord. It is imperative that my
Mentioning upon notice.
my lord, this is a civil division application. There is no caveat. My
Give it up.
lord, any day on Monday.
Number, please,
My lord,
let me see.
mine is also civil matter since the court number 19 is not sitting. 21st is the date, my lord, and they say that in view of the bench not functioning, 21st is the date, my lord, for hearing of argument. And the application for rejection of plaint has not been entertained. The suit itself is not maintainable. And therefore, 21st, the court is proceeding without disposing of my order 7 rule 11. Therefore, it's new motion since.
Lordship, may I be permitted to
Yes.
mention a matter under new motion, Lordship? It says CO. We have prayed for recalling of an order where a child, 4 years old, who is suffering from asthma, we had prayed for modification of the visitation period. It's from every Saturday 2 to 5 p.m. We had prayed for modification, but instead of hearing our prayer for modification, direction was given to submit an explanation by the custody or to be given to the father instead of the mother. And the next date is on 3rd for hearing of that explanation, Lordship.
Next date is on?
3rd February.
So the court will be back by 22nd. So you can wait till 22nd, madam.
Lordship, we urgently require
The next date is 3rd February, I said.
My lord, may I be
Court will be back by 22nd January.
My lord, may I be permitted to mention the determination of Honorable Justice Shampa Sarkar? My lord, this is a new motion and matter is a probate matter. The next date from the trial court is 16th of January. And if the revisional application is not heard, the total revisional application will be infractual because trial court date is very soon. So kindly keep it,
My lord, may I be permitted to mention an application for expeditious disposal of a divorce suit, my lord?
It is not urgent, madam. You can take it.
My lord.
Hmm.
Yes, yes.
The department is not accepting my case. The matter has been made
No. Leave has been granted.
respect of file, without filing without certified copy.
Yes.
Now the difficulty with the presentation form, I cannot see the date. The department is not accepting. The matter has been made. The arbitration of the rejection of section, any date convenient. Any date convenient.
ওটা ডিপার্টমেন্ট দিচ্ছে না কেন? Leave that. Take it.
May I address this now?
Level speaking, my lord, a regular matter, regular bench matter, mentioning.
I will, court number 19.
My lord, I am.
Yes,
My lord, item number 941. My lord, what has happened in this
of
matter?
court number 19.
Of court number 9.
Yes.
What has happened in this matter is that interim maintenance was passed by the Honorable Judge of Shirampur Court of 25,000 funds. And there filed, my client has filed a disciplinary application to make the husband. And he wants to settle the entire amount by making of 35 lakhs to the side. And they have been approached and there were talks of settlements. Probably the matter will be settled upon payment of 35 lakhs to the bride. Well, the lower court date is on 15. It is not possible for the husband each and every month to pay 20,000 per month. Rather to get rid of the problem by making payment of the entire sum. Well, the matter has been filed since since October 2023 pending. And now the lower court date is on 15. Twice the date has been obtained upon that this court, this matter is pending and this matter is pending over there. The adjournment has been sought for. So
Put
let us be try for and thereafter settle. If it is settled, my lord, on one day it will be settled.
Have you
and
put the
thereafter-
other side of notice?
Sir,
It's
you
a
have to
compromise
give-
matter.
sir, it's actually civil revisional application, where they have not filed
Sure,
it yet. Well, they have, I have been continuous telephonic conversation with them. I will give them notice if the matter is put on 15th or on 16th, Monday or Tuesday, any day, they will be there.
Please give the number. Please give the number.
My lord, under compelling circumstances mentioning this matter,
Yes.
this matter is running as an item number 797 of dated 8/1/2024. What happened, my lord? The defendant, my lord, the hearing opposite party, my lord, filed a application before the learned suit for recovery of khas possession and eviction. In that matter, I filed an application for 7172 of the West Bengal primacy tenancy act. That has been rejected, my lord, without any order. And my lord fixed on, my lord, 16, that is Tuesday.
For training of issues.
Yes, my lord. If the matter was not taken up, my lord, my application will be infractuous, my
Not
lord.
at all. It will not be infractious at all, sir. You are aware of the CPC.
My lord, because, my lord, this matter is running more than
I
6
also
months,
have
my
little
lord.
knowledge of the
Because they
CPC.
have
I
not,
don't think it will be
landed court is
infractious.
inclined to grant any time, my lord, because unless the
Even
order,
if issues are framed, how will your application become infractious? Please explain, sir.
my lord, because I have challenged the order passed by the
It can be
7172.
taken up by the regular bench.
Pardon?
It is not that urgent. It can be taken up by the regular bench. Please wait till the regular bench
My
comes.
lord, because the
It is
matter.
not urgent, sir. I do not find any urgency. I am sorry.
Then, my lord.
One matter, my lord.
The lordship is taking, my lord, regular bench matter. আর কোড নাইন কত সময় লাগবে?
Milord, may I have your kindly leave to mention a matter, Milord? This is appearing as item number 2106 in her ladyship's
What
loss.
is your urgency?
Milord, the only urgency is, Milord, that the next date is fixed on 16th of January.
For what?
For Milord, final disposal of the petition, Milord, under Guardians and Wards Act. Milord, the impugned order has been challenged in this present revisional application so that that may be modified. Modified to the extent subject to
I do not
in
understand.
presence of,
What is the order challenge?
Milord, in the impugned order, Milord, the learned court had permitted the petitioner to give the visitation right, Milord, but only for a day, Milord. And that is to that extent, Milord, a revisional application has been filed for modification of the same.
This can wait till the 22nd.
Milord, on 16th is the final date, Milord,
The date of what?
for final disposal, Milord.
That is a different issue altogether. It has no connection whatsoever with the visitation rights.
Milord,
Isn't it? Final disposal of the case itself.
yes, Milord,
Final
but the
disposal
entire
of this-
matter will go infractuous, Milord. One of the order has been challenged before this honorable court, Milord.
So if the final hearing starts, matter becomes infractuous when it's pending before the High Court.
সিঙ্গেল বেঞ্চ ম্যাটার দিয়ে
No, isn't it? Please wait till the 22nd. Court number 19.
Two contempt applications.
Upon notice,
No, Milord, I am giving notice that is appear tomorrow, Milord.
please inform the other side and come back. Since it's extension, please inform and come.
My lord, may I mention two contempt applications?
Court number 19.
Contempt application.
Court number 19.
No, 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 no.
Please wait. Court number 1, please wait. 10 minutes wait.
Courtroom number 19, my lord.
Yes.
But I am an owner of the property. My lord, this is my land, my lord. The responding company is not allowing me to enter on the ground.
কোড নাম্বার 19 কে বল না দেবে কি দেবে না ফোন কথা
Like continuing in my
This is a group 1 matter, isn't it?
দেবে কি দেবে না তুই জানলি কি করে ওখানে বসে আছে দেখবি
Court number, writ petition group 1 matter. Please wait.
Courtroom number 19.
I'll take up group 1 matters.
মানে এই 19 is over
My lord, courtroom number 19.
My lord,
My lord, this is happening in the month.
বল না
Number 5, 8-5, my lord. My lord, the urgency is, my lord, that the advocate commissioner was appointed, my lord. Advocate commissioner did not rely on the sale deed and other relevant documents. In the examination, the advocate commissioner said that I did not even go to the site while conducting my work, commission. My lord, whereas the order dated 3/3/2023, my lord, the court said that the report is sufficient, my lord. We have challenged that report, my lord. The date of hearing is on 15th, my lord.
Hearing of what?
Hearing, preemptive hearing, PH.
You can wait till the 22nd, no difficulty.
My lord, the next date is on 15th.
Peremptory hearing doesn't end in a day.
না বলছে বলে হোক না
Even if it starts, you have no difficulty. Your petition doesn't become infructuous, sir. You can wait till the 22nd.
My lord.
Yes. What is the order that you're challenging? What is the order that you're challenging? It should matter. What is the order that you're challenging? You have not done your homework. Please get ready and come back.
My lord, may I be permitted to mention one matter? My lord, this is a trial court matter. This is execution. Your petitioner and you have filed an execution application. This execution application pending till 2016 and till he has not decreed. And your petitioner is
You're asking for expeditious disposal. You're asking for expeditious disposal, which can wait till the 22nd.
My lord,
It can wait till the 22nd, sir. Please do not encumber this court.
my lord.
I understand. You can wait till the next week, 22nd.
my lord
Group 1 matters.
yes my lord may I submit to lordship my lord may I mention to your lordships my lord may I mention to your lordships my lord group 1 matter my lord is post happy new year firstly
Happy
and secondly my lord I make some lordship my lord this is a matter of 2019 the matter was heard at length for few times long date Mr. Basu is appearing the rehabilitation yes rehabilitation but lordship has given direction for filing the affidavit they have not in the meantime 23rd to 24th my lord 5 persons has died with cancer for the air pollution water pollution of rehabilitation of Nagrasota Asansol lordship member lordship has directed the matter to appear in the list I appeared before lordship I mentioned the matter before lordship but matter is not appeared my lord how many I shall lose my client
Is it a hearing matter?
yes and lordship has given direction kindly see the orders
It will appear after 23rd onwards.
my lord kindly take
This court cannot take up.
my lord I will inform Mr. Basu kindly my lord reach the matter I will inform the Mr. Basu day after
Not mention hearing matters because it will be taken up only after.
my lord maybe there are good many matters will appear before lordships but when my lord my submit to lordships
Hearing matters now. So
when my lord has given direction the matter will appear in the list and not is appearing in the list
there has been a change of circumstance, sir. This court is taking up the determination of court.
my lord may I submit kindly my lord I
Not
bona fide
mention
submit
hearing matters,
I
please
bona
mention
fide submit to my lord the date is not my lord extending on the change of circumstances I have lost few of my clients because of the having the cancer of the pollution.
What I've said, sir. If you want a release, I can release the matter. If you want a better court who will hear your matter, I can release the matter.
Kindly release the matter.
Yes. Nini. Kalke
My lord-
rakhan for release.
My lord, may I permit to mention for upgradation?
Urgency.
Urgency, land acquired by the government and compensation yet not disbursed, my
The
lord.
writing of a notice.
Yes, my lord.
My lord, the petitioner made an application under section 10 Highway Act 1964 and the private respondent encroaching the public land
On notice.
upon notice, my lord, upon all, my lord.
Your Lordship, may I be
May I
permitted
be
to mention one matter? Your Lordship, the land of the petitioner has been acquired by National Highway Authority and your Lordship, yes, your Lordship.
My lord, may I be permitted to mention on motion when upon notice and mentioning one without paying any compensation?
My lord, may I be permitted to mention the upon mentioning the private respondent My lord, they are, my lord, the unauthorized, my lord, the.
Upon notice.
Yes, my lord.
Give
For extension of interim order.
Upon notice.
May be permitted to mention on matter, my lord. On matter, my lord, this is running as item number 323 of today's list, my lord. But before vacation, my lord, I have already mentioned this matter before your lordship, and your lordship please to pass a direction upon me to mention it after vacation. Yes, my lord, this is the item number 323, my lord.
The ring matters or at the
No, motion, new motion. My lord, fact is that during pendency of this matter, my lord, private respondent forcefully and illegally excavation the blackstone of the land of the present petitioner.
Are you mentioning upon notice to the other side?
Yes, my lord, I have mentioned it.
You are mentioning upon notice?
Yes, my lord.
Give the number.
My lord, I am praying for.
One motion matter for upgradation.
Yes.
Petitioners are the recorded owner of the land. Petitioners made a representation to the LA officer, but LA officer did not disburse the compensation. Yes, I thought.
My lord, may I be permitted to mention, my lord, one matter I could not mention inadvertently, my lord, of court number 19, my lord, 787 of the combined list, my lord. What happened in this case, my lord? The learned judge, my lord, without hearing the application filed by the defendant on order 7, under order 7 rule 11, my lord, only dismissed in absence of the, my lord, advocate of the plaintiff, my lord.
Give the number.
My lord,
Give the number.
my lord, I am praying for a leave to file this matter. My lord, the urgency is, my lord, I am a flat owner.
Group 1 matter.
Group 1 matter, my lord. My lord, I am a flat owner of an apartment developed by some Asian enterprise, my lord. My lord, I have received on notice on 29th of December 2023, and by National Highway Authority of India, they are asking, they are direct upon me that this notice is for the removal of unauthorized occupation, and they direct me that we can remove all the necessary things within 7 days or make a representation to the department for a hearing. My lord, the hearing was happened on 5th of January 2023. When am I asking for the recent order, they said me that the last notice was the final notice and now no further notice will be given to you. Yeah, so my lord, when I'm asking the demolition date, they can say it any day they can demolish the building. My lord,
Final notice is not required. You need the order, the reasoned order.
my lord, I am the flat owner, and I have all the clearances from the North Dom municipality and also the Asian enterprise who give me the notice regarding the.
But the authority can still acquire and pay
My lord,
compensation.
kindly fix it on one day. My lord, hard mass.
File and come back, I'll fix a date. File and come back, I'll fix a date.
My lord, may I be permitted to mention one matter for upgradation in daily list. My lord, the urgency is that the private respondent is occupying the land of the irrigation department, and for which the ingress and egress of the.
Upon notice?
Yes, my lord.
Yes. Upon notice? Upon notice?
I mentioned one matter. My lord, I have a lot of land. I honestly the officials of the company not allowed me
You're mentioning upon notice? Give them. Yes, call the days list, please.
My lord, item number 1, my lord, Mr. Pushanjit Mukherjee, due to some personal difficulties,
You're
cannot
asking
come.
for time?
Yes, my lord.
I have no objection to that extent. No, lordship, kindly remember this is the matter.
My lord,
This
Mr.
is regards to
Pushanjit
the.
Mukherjee's family member.
Wait.
I have heard you, sir. Please
Wait, learn something. This is the matter lordship may recall. Delivery of a deeds, a concern. Milord, I have taken out an application of recalling. Lordship was the last occasion pleased to Milord pass an order to that extent that affidavit would be exchanged in the meantime. Milord, the yesterday after the long gap, Milord, we have received the Milord opposition. To opposition of the Milord section 5 and the recallings.
on record.
Yes, that is the whole things, Milord. I also require Milord time to deep.
Let it adjourn for some time.
Yes, at least 2 weeks, Milord.
Lordship,
Yes,
Lordship, due to demise of family member,
has been stated, sir. Why do you want to repeat? On prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 6th February.
My lord, even item number 3 and 7 also, my lord, Mr.
I'll just call, please wait, I'll call them.
I wish the lordship the
Because
happy new year.
Thank you, same to you, same to all of you. There may be other respondents also, so please wait. Item 2.
On behalf of the petitioner, my lord, there was a direction to serve, my lord.
Yes,
Copy has been served, my lord. Last, my lord. But this is the affidavit of service, my lord. My lord, this contempt is against the violation of the order dated passed by my lord on 2nd February 2022, my lord. There was a direction upon the concerned BLN LRO to dispose of my representation my lord, within a week, my lord,
Where is the track report?
my lord, last page. My lord, this is the second time service. My lord, I have annexed the letter as well as forwarding letter as well as the track report, my lord.
The postal receipt number is different from that of the track report.
My lord, last.
Yes, this is 255.
My lord, I have annexed the track report as well as the letter as well as the
64. No, the track reports are different from the postal receipt.
May I
Please give the numbers. Please compare the numbers of the postal receipt and the track report.
এক নম্বরে জুনিয়র ওর নামটা কোথায় নিয়ে গেল তো মনে হয় ঠিক আছে আমি বলছি।
Yes.
Yes, ma'am.
You've tagged some other track report with your postal. So it's not yet served.
2251 my item dispatched. He has left it, my lord. He has not annexed it with the affidavit of service, my lord.
Served.
My lord, item dispatched, it's showing. But
That
same
is not served.
previous track
The-
reports also shows
the-
that.
The subsequent track reports?
My lord, it's saying no item dispatched.
After
Previous.
that, there should be other subsequent track reports also. Item dispatched is not complete procedure.
Kindly make it not today, my lord. Come back.
Very well. Not today.
Not today, ma'am. Deep level.
Contempt application needs to be served.
My lord, my lord.
Next. Not today. Item 3.
Lordship, in this matter also, landed advocate Prosenjit Mukherjee is appearing, Lordship.
Service complete.
Lordship, I do not have the instruction.
Do not have instructions.
There is a bereavement near.
I have
Well,
heard.
Lordship.
I have heard. On prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 6th February.
6th February, Lordship. I'm good.
Next.
Yes.
6th February. Item 4.
Lord, this is my application. Lord, this is 14. Now, my lord, kindly appreciate, my lord, this is the order dated of your lordship, my lord, on 21st of April 2022.
Prayed for time on the earlier
Yes,
petition.
in the month of November. Nothing has been intimated to me.
It's also over. So now let the contact come.
Because, my lord, that is the petitioner, I made appeal to the
Petitioner,
that is the
State.
state, my lord, I appeal আসতে কথা বলে না এত উত্তেজিত কেন?
উত্তেজিত না, আপনি
দাঁড়াও
বলছেন
না,
পিটিশনার।
আমি একটু আসতে বলছি,
স্বাভাবিক।
শোনো, তারপরে তুমি বলো ballot state find appeal. After that ballot we are forced to withdraw because ballot Sushma Sengupta filed the appeal.
Yes.
Ballot after that ballot again we wanted to file appeal and ballot appeal was filed by PC number not yet the appeal number is not mandamus appeal number is not ballot given. Only ballot the approval number DC ballot was given. So I play some time ballot to see the
Kindly
appeal
see, my
number.
lord, then the kindly appreciate the attitude of the learned advocate.
That is not that.
My lord, kindly have a look at the order. Kindly have a look at the order. Kindly have a look at the order.
Though he is not in the our panel, my lord, he filed that and honorable division bench, my lord, took that point. Why you filed that appeal? He can't, my lord, give any explanation. For that, we are forced to withdraw that appeal and again we filed that.
My lord, possibly is an incorrect statement. Nobody was forced them to, I was appearing in that appeal. Nobody was forced them to withdraw the appeal. No.
But he could not have filed the appeal since he is not in the panel.
Yes. So, my lord, so
Technical.
many things happen in between. My lord, I don't want to utter all these things.
Let us-
Now, my lord, now
let-
kindly
let
see,
us
my lord, on the last occasion, the time was short for entirely praying that entirely order will comply. Order will comply with. Now they have come up with a new story.
It was your submission
Yes.
on the earlier date that you do
That's
not
why I
want
have
to
said.
refer-
My lord, if the appeal was not filed, my lord, I must comply with the order. I am bound to comply with the order.
That was your submission on the earlier
Yes, my
date.
lord. Only for that is now, my lord, I came to know today, my lord. I came to know today, my lord, that appeal was filed by EC number, not mandamus appeal number was not.
I'll grant you 1 month's time, Mr. Day. There should be a stay order, otherwise I have to
Yes, ma'am.
continue with
My lord,
this.
I am continuing that process, my lord. I have yesterday, my lord, I told my landed friend, my lord, that huge amount you will get, my lord.
But the appeal has been papered. Kindly see
my
the,
lord,
kindly
today,
see.
my lord, I am not filing appeal, my lord. There is some.
Mr. Day says he has knowledge of the appeal today.
My lord, I am ready for my lord part compliance also, my lord.
There are two sets of order. One is either you initiate a proceeding under the 2013 Act or direct purchase. My lord, admittedly proceedings lapsed.
My lord, I have.
And 2020, April 20,
But
2022.
when I came to know that there is a, my lord, they filed an appeal, one London advocate filed an appeal. My lord, I may not want.
Learned counsel for the alleged contender seeks further accommodation on the ground that the order under contempt has been carried in appeal by the state. Paragraph, let the matter appear under the same heading on 20th February. Should be sufficient for a stay order at least. 20th 20.
Yes, ma'am.
February 20. Next.
I just filed appeal
For the contempt.
filed an application for comprehensive. I want to challenge that because they will make a false report, make a false affidavit.
On the
Only 10 days time I required because I know, I think my land is well aware of the consequence of that. On the face of the record, if a affidavit is shown, a false affidavit, then the 340 is attractive. I want to show it, logically, allow me to file this affidavit because the client is a poor client and he is living in not 24 hours.
Learned counsel for the applicants petitioners seeks extension of time to use the exception as sought. Paragraph, let the matter appear under the same heading on 30th January.
Well, get to it.
Next.
Item 6, my lord, they have filed a compliance report, my lord, we have filed an exception. No,
my lord. No, exception. But I want to make by 1 month's time, my lord, to go to the last time received.
1 month's time.
Yes, because my lord, there are some mistake, my lord, on the part of the authority, my lord, authority. That's why it will be corrected sometimes required.
And in a lapse proceedings, my lord, in in respect of other petitioners in other writ petitions, my lord, they have assessed the
yes.
market value.
That is
And in
that
this matter, my lord, they have in the last lapse proceeding, some amount was placed for clearance. That is yet to be cleared. And
That's
they are,
why I'm
they are
praying for.
saying that should be followed.
That's why I'm praying for at
No,
least
but
1
they
month.
have realized their mistake. That's fortunate enough. So let them be given
Fine.
some time.
My lord, 1 month, at least 1 month, sir.
1 month.
You know, my
Exception.
I acknowledge I
Exception.
reply to
by
the exception.
Applicants petitioners is taken on record. Paragraph on prayer of the alleged contemnant, the matter is adjourned. Paragraph, let the matter appear. Learned counsel for the alleged contemnant on prayer. Learned counsel for the alleged contemnant seeks a month's accommodation to comply with the order.
Well, yes, I will try. Well,
Comply with the
some
order under contempt.
sometimes may require that's true.
13th February.
13th February.
1-3.
Seven.
I am for the national highway.
Seven, my lord, in this matter, like Mr. Prosenjit Mukherjee could not come to because it was very bend of his family.
Petitioner.
Yes, madam. The matter may be listed 6th February like other two matters, which 6th February, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 6th February.
Yes.
Excuse me.
It my lord, I am for the petitioner. I am for the respondent in this matter. Already report in the form of an affidavit has been filed, my lord. The latest report, my lord, that the concerned executive engineer has already sent letters to the ADSR Kagdeep and also to the BLLO. I have got 2 letters, but not the report, only the
My lord, may I, my lord, inform only one thing, my lord? My lord, during my lord pendency, my lord, we were, my lord, approached, my lord. Approached, my lord, for, my lord, we were, my lord, pressing for 2013 Act to be implemented. They, my lord, approached.
Without acquisition.
Without acquisition. They, my lord, approached us, my lord, with the offer that direct purchase policy, my lord, can be invoked. They are willing to, my lord, if they are, my lord, agreeable to direct purchase policy, my lord, my client is agreeable, my lord. I have had a talk, my lord.
Then we shall have to talk.
My lord,
But
I have
only
been
the
approached,
thing-
my lord, I have specifically state, my lord, I have been called, my lord, I have been called by the LR, my lord. From the LR office, my lord, I have been called.
এই আমি আর জ্যোৎস্না রায় মুখার্জি আছি লিখে দাও না একটু আমার সাথে খাওয়া জ্যোৎস্না রায় মুখার্জি Your lordship kindly see that
এদিকে স্লিপ
আর একটু
ওই তো না এগুলো ফাইলের সাথে
তোমার সময় চেনে
So you want to directly purchase the land?
No, Lord, we have already written that.
Your proposal is to direct purchase.
That's what is there. But let me, Lord, the person concerned, the executive engineer is busy in the Kagdeep, Lord, because of the Gangasagar Mela. He have just sent these 2 letters. Just I have shown it to
policy বলা আছে আমাকে
anyhow, this has been, he has told me just to submit these 2 letters. Then after Gangasagar Mela, we will settle it out.
Says that you are agreeing to purchase the land directly. The petitioner also agrees to your proposal.
foregoing my right for 2013 Act.
But your lordship kindly see the how much of land has been taken by the government. That I will show you.
So how long will you take to complete the?
Just after the Gangasagar Mela, your lordship keep any day. Any day. 14th is the Gangasagar Mela is starting. They are all busy over the Gangasagar Mela. Your lordship knows it in Kagdeep.
The writ petition can be disposed of. I'll give you some time. Please complete the direct purchase process in the meantime.
That will that.
Yes?
Yes.
No use keep.
My lord, kindly, my lord, records my consent, my lord, with regard to the policy, with the amount, my lord, of the direct purchase policy, that is to be assessed, my lord.
Yes, that the authority.
That's what we'll talk.
The difficulties, my lord, when we go for hearing, my lord, before the collector office, they, my lord, indicate that you give a consent for the amount as well as for the, my lord, without disclosing the amount previously.
That is
that becomes a difficulty.
If you are not agreed, you don't say that we are not agreed. You can very well say to them. Already you are in the court.
Because by another letter, the executive engineer has written to the ADSR for providing the current market value.
Okay. Yes.
That's a positive approach.
Great.
You can have some hope on that.
No, no, no. It is internal letter. I mean,
My lord, may I, my lord, be served a copy of that, my lord, note?
Not- do I need to have it since your lordship is?
My lord, my lord.
It is not needed.
Your lord, my lord.
Since your lordship is keeping it for further hearing, on that day I will come with it.
Hearing and disposing of the matter.
Your lordship is disposing it.
Not necessary this matter because you have a proposal for direct purchase. He is agreeing to it. So I'll give you maybe 4 months to complete the entire procedure. It will take some time because the cabinet approval is also
My lord,
required.
certainly,
It will take
certainly,
4 months.
certainly.
After that, contempt.
I am afraid of this contempt.
Like every other.
Very afraid.
It's unfortunate that you are afraid. Your authority is not afraid.
But what can you lordship?
That's the difficulty.
Very afraid of the contempt.
Heard learned counsels for the parties. Learned counsel for the respondents produces 2 letters issued by the executive engineer, Kagdip Irrigation Division, dated issued on 8 December 2023, and submits on instructions that the respondents propose to purchase the plot of the petitioners directly, since the said plot has been utilized for construction of ring barn without acquisition. Stop. The petitioner agrees to the proposal for direct purchase subject to payment of current market value. Subject to payment of current market value of the plot in question by the respondents.
My lord, grateful.
That has been asked for. So that is their intention, I believe.
Grateful.
Paragraph in view of the above, who should be responsible? The executive engineer.
My lord,
The executive engineer should initiate proceedings.
Kagdip Irrigation.
The
Kagdip Irrigation Division.
executive engineer, Kagdip
Irrigation Division.
South 24 Parganas, being the 6th respondent hearing, is directed to initiate the process of direct purchase of the plot in question and conclude the entire process within 4 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Who are the authorities to whom the executive engineer will send? Because only he is not the authority.
My lord, the collector has no role to play here, my lord. My lord, for direct purchase, my lord, for acquisition is involved, my lord, it goes from the collector's office. My lord, for direct purchase policy, my lord, the executive engineer has to, my lord, send this to the secretary for approval, my lord.
So the
Secretary
first
party
respondent
আছে?
will also be
Secretary party আছে?
Party. Service to secretary.
Collector ही হবে গো।
Collector sir এখানে role নেই তো ওদের।
Let it be the appropriate authority. That will be
first,
the.
so then it becomes difficult later on. Let it be the first respondent.
My lord, 5 also, my lord, I think. Respondent number 5.
The secretary also.
Irrigation department, my lord. Irrigation and waterways.
Respondent numbers 1 and 5 are also directed to take necessary steps for direct purchase of the plot in question within the stipulated time frame.
My lord, grateful.
Paragraph, since nothing further remains to be adjudicated in the writ petition, the same is disposed of. Paragraph, no response, since no affidavit.
In my report, last time I said that the joint verification was there and the land quantum of land order has been taken.
Earlier,
Earlier, that was on record. So these 2 letters, your lordship is keeping it on record. Your lordship.
My lord, only one.
letters in my order.
Only, my lord, one thing, my lord. they have, my lord, in their report, my lord, indicated that the quantum of land, my lord, is certain, is to
Very only
certain
this
extent.
certain plot of
Now, my
land
lord,
in
my
only in
ex-
one plot.
my
Other
lord,
plots you have not taken.
my exception was to the effect, my lord, that a certain quantum would be increased, my lord, because of the fact that the river bed, my lord, has, or the river has, my lord, engulfed certain plots of the land. Let that point be, my lord,
Will
kept
be
open.
increased does not do.
My lord,
No,
my lord,
no,
let
will
that
be
point
increased
be, my
does
lord,
not.
kept open. my lord.
Without the proposal for direct.
Yes,
And
yes.
record
Will
is
be
subject
increased. That cannot be substantiated. Will be increased. That's depend upon
My lord,
already the land
let
has
that-
been
my lord,
verified.
my only
And
submission will be, my
quantum
lord,
of land what has
let
been
that
taken.
point
That
be
has-
kept open, my lord. Otherwise, my lord, this will, my lord, act, my lord, for
file the report. ও যেখানে agrees to the proposal বললো না? What is the quantum stated in the earlier report?
my lord. Kindly seize, my lord.
In my report also is there.
My lord, page number 3 of their report, my lord. For serial number 1, my lord, 3 of the plots, my lord, the remarks is river bed.
কোথায় গেল কোথায় রে?
Assess the blocks.
My lord, my lord, page number 3 of their report, my lord. The state's report, my lord.
Yes, page number 3, paragraph 6.
Paragraph, my lord, 6, my lord, the chart they have made out, my lord.
It's not
The detailed chart I have given, my lord.
And my lord, the joint field verification report is also there, my lord.
No, no, now we have given a report in the form of an affidavit. That is there.
the chart, yes.
Therefore, only follow something like that. It is there.
My lord, kindly, my lord,
Your lordship kindly come to R1, page 4.
They say it is river bed.
river bed, my lord. 3, my lord, river bed. Now, my lord, in my exception, my lord, I have stated that, my lord,
Your
those
lordship
were,
kindly come to
when it was, my lord,
R1, page 4.
a second, sir. When it was, my lord, my lord, utilized without acquisition, my lord, those were, my lord, those belong to the petitioner. Later on, my lord, they were engulfed by the river, my lord. That was my contention. So, my lord, that, my lord, cannot be adjudicated, my lord, by
Engulfed by the river. How can an embankment?
subsequently, my lord, subsequently after
How
the
can that
after
be?
the
No,
utilization.
that cannot be acceded to.
My lord, the
That
river bed,
cannot
my
be-
lord,
no.
my lord, that was, my lord, the contention, my lord,
Whatever the
throughout.
land has been taken.
That be ascertained now?
My lord, ascertain, my lord, from their records, my lord, it can be ascertained.
No. That
From
is
their records.
uncertain.
Thanks. The measurement has also been done here after the petition was filed.
My lord.
So how does that help you?
আমার কাছে এটা
My lord, kindly considers, my lord.
Your lordship kindly see the page R1, page 4.
Sir, এক second, আমি বলে দিচ্ছি। My lord, for Bablu Maiti, my lord, the plots, my lord, these 3 plots, 2997, 2999, and 3000. These,
Only 16 decibel, something like that. Your lordship
these plot might not have been, my lord, the remarks is engulfed, my lord, by the river bed. My lord, these were, my lord, my lord, my contention is, my lord, these came in, my lord, these were engulfed in the river bed at a later stage after utilization.
No, the land engulfing does not come in the repetition.
How can you prove that at this stage?
Well, after joint field verification,
I joined the issue on this submission. I joined the issue on such submission.
When was it engulfed? When it went
Yes,
into the river? That is, you cannot show it now. You cannot prove
My
it.
lord, I'll accept, my lord, the utilized part.
Submission করে দিও না
Case before the authority when you are called.
My lord.
It's your case before the authority.
My lord.
If you have documents, you can place it before the authority.
Yes.
My lord.
Love it. Yeah. Yes, next matter. Because it's difficult to ascertain at this stage.
Difficult to ascertain, my lord, but that is what, my lord, the difficulty is when it, my lord, the compensation is, my lord, awarded at such a belated stage, my lord. Because the river bed is, my lord, continuously, my lord,
But that cannot be taken into account at this stage.
For whose fault, my lord? Not for the petitioner's fault.
Then এটা নিয়ে নেবেন না এটা দেবেন ধরো এটাকে ধরো No, not the report, not your lordship. I'm filing the report, your lordship.
My lord, my affidavit of service, last officer, your lordship. Direct.
Respondents are there.
My lord, I'm filing the report, my lord, your lordship.
Have you served a copy?
Yes, তোমার দিয়েছে সার্ভ করেছে
I'm for private respondent.
এই রিপোর্টটা কি স্যার?
Yes, what is the report?
My lord, the second round of litigation, the lordship, my lord, I will file an exception to this report. My lord.
You file an exception?
Exception.
Okay.
My copy may be served on me as well.
Yes?
My junior is, a copy of the
Please
report
serve
may
a
be served
copy.
on.
Would you please serve a copy to the.
So my junior is there, he will collect from you.
এই আমার কাছ থেকে নিয়ে নিও,
আমার এর ক্লার্ক কাছে নিয়ে নিতে আপনার।
নিয়ে নিও আমার কাছ থেকে।
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 7th February.
My lord.
Please serve advance copies.
Lordship.
Next.
Pradam for respondents 7 and 8. I beg to appear for the petitioner, my lord. State, since last occasion nobody appeared on behalf of 7 and 8, my lord. The lordship directed me to serve.
7 and 8
Yes,
are
ma'am. He is representing today. But I am filing the
Lord,
affidavit
I'll have to
service.
take instructions from my client, my lord. My lord, kindly
Lord.
advance the matter for a week, my lord.
দাদা এটা নিয়ে নাও।
But this is third round of litigation, my lord. My lord, the land of the petitioner, 1.32 acres of land of the petitioner has been utilized by the concerned Panchayat Samiti for the purpose of community tank. My lord, when the excavation work was done, my lord, I objected, but that was not considered. I filed a writ petition. My lord, Honorable Justice Nizamuddin directed the concerned BLRO to inspect and, my lord, whether my land has been utilized or not. Accordingly, my lord, the BLRO inspected and found that 1.32 acres of the land, Rayati land, my Rayati land, has been utilized for the purpose of construction of community tank. And that report was forwarded to the ADM for taking necessary action. Since no step was taken by the ADM, I filed second writ petition. Your Lordship directed the ADM, my lord, to consider the report of the BLRO and pass necessary order. ADM says, my lord, since the land was not acquired, so, my lord, question of compensation does not arise. But this is the subject matter of challenge in this third round of litigation. Last occasion, your lordship found that since the Panchayat Samiti has utilized, my lord, and nobody appeared, my lord, for that reason, my lordship directed me, my lord, to serve upon.
It's correct in his own way.
Yes,
Since there is no acquisition, there cannot be any compensation. But there has to be a direct purchase or a fresh acquisition.
yes, that is. Anyhow, my lord, since my land has been utilized,
Lord, I'll have to take instructions.
Let me take instructions and come back.
but a short time may be given, my lord.
Lord, for a week, my lord, kindly.
Affidavit of service. Learned counsel for respondent number 7 and 8 seeks to take instructions in this regard. In this matter. This matter. Paragraph, let the matter appear under the same heading on 31st January.
Question.
As your
I'm
lord
grateful.
Lord, can it be on February, my lord?
Acts of the
You
time.
said 1 week.
Lord, you granted more time.
First, when do you want to come back?
1st February.
1st February? When?
1st February.
1st February.
Well, I am for the petitioner, my lord. The last occasion, your lordship, by an order dated 20th November 2003. My lord,
Report policy was challenged. The learned advocate general was directed to serve
no, order is dated 28th November.
for filing of evidence.
No, report. What are you saying?
Reports.
Would you
not
find us
evidence.
But you have submitted, you will be filing report.
My lord, that is the advocate general, my lord, is the.
I have challenged the legality and values of the policy.
Court, my
But
lord.
they are submitted, we shall be filing a report.
If virus is challenged, the advocate general has been served.
But they have.
Yes, I believe notice was served or somebody on last occasion.
I do not find any
Mr.
record.
Tarok Koron appeared on behalf of.
Tarok Karan was appeared.
Yes, he is appearing on behalf of the advocate general.
My lord, give me a short date, my lord. I inform the advocate general. Yes, my lord.
Yes, I appear on behalf of.
So,
Yes, my lord.
Well, they have challenged the virus of the paragraph 39 of the
রিপোর্ট দেওয়ার কথা ছিল এই যে
my lord, this is here question of law, my lord. The Advocate General plead the matter, my lord. Whether notification of
The question is whether the policy will take policy will be governed the field or not.
He's pleading me, my lord.
Apart from the act and the rules, but the policy framed by the government will be acted upon for deciding the appeal.
So you are really not challenging the virus.
Yes, yes. Challenge values of the state mining policy.
Applicability, it's different.
Yes.
from virus.
He is not challenging the virus, he is challenging the applicability of
the policy.
No, why? Because it has, my appeal has been decided. Your lordship kindly see the input order. If your lordship kindly come to my lord,
Your prayer first.
prayer is my lord kindly see my lord. My
go ahead in the prayer.
কি বলছো চুপ করো না জেনে দিলে বলছো দেখে বলো না দেখে বলছো কেন
Yes, you say that the
Case
policy is
34.
not applicable in an appeal under Rule 51.
Yes.
Applicability, not virus.
Mala kindly come to page 34.
Yes, 34.
Yes.
Page 34, paragraph 1. Prayer A.
Yes.
A declaration to the effect that the West Bengal sand mining policy is not a statutory and has no force of law for its application during the course of hearing of the appeal.
Legal and valid one.
So you're challenging the applicability, not the virus.
That is the
They are
mode of
two different
that
things.
is no matter. That is the mode of according to my humble submission, my lord, the virus is challenged in this way. The prayer is made in that form.
You have not challenged the virus.
But here, my lord, kindly see.
You have challenged the
But
applicability.
that means
of
my
the
appeal, not appeal, because my appeal has been decided on the basis of the policy. Kindly see the order.
You say that the appeal could not have been decided on the basis of the policy.
Yes.
It should have been decided on the basis of the statute.
Yes, and
That
rules.
means you are not challenging the policy. You're challenging the
But
applicability.
because
of
the appeal has been decided by alleging the applicability of the rule itself, policy itself.
You are challenging the applicability.
Yes.
You are not challenging
What
the
more can I do, my lord?
You are not challenging the
No,
virus.
your
The
lordship can see.
applicant's presence is not necessary in this matter.
No, I said, my lord, policy cannot be considered as a legal and valid one. My lord, kindly see.
Where have you stated?
My lord, kindly see the
Last line, lordship. Page 34, prayer
that is
A,
the
last line.
prescribed mode of, my lord.
Yes, sir, what do you say?
My lord, in this matter, then I have to, my lord, some time be granted, my lord. Mr. Banerjee, he is leading me, my lord, at the Advocate General, my lord. Let them come and they will, my lord, my lord.
And my appeal, your lordship directed them to appellate authority to decide the appeal. Now, Rule 51 of the mining rules is governing the field. They have to consider the appeal in terms of section Rule 51. The appellate authority confine the consideration on banking upon the state policy or money policy and rejected my prayer. That they can do. The appellate authority prescribed mode is there.
You are making a submission and you are asking for something else, Mr. Shamanto. I'm sorry to say this. Your grievance is that the authority has relied upon the policy and dismissed your appeal. That is your case. But why are you challenging the virus of the policy?
Because according to my humble submission, it cannot have a statutory force. It has no force at all. It's not alleged to be a law.
Policy doesn't have a statutory force.
Yes.
So the virus need not be challenged for
But
that.
for that reason, I had to challenge me because it's framed by the state government, my lord. The rule, my policy is framed by the state government.
So the state government.
Not very clear.
Why are you laughing?
Last time also.
Why are you laughing?
Application is one thing. Virus is another thing, Mr. Shamanto. You are mingling up with that.
After all, I have challenged the policy itself. Whether it is.
If policy have no force, then how will change the virus?
Well, the appellate authority said so. Man, kindly see the input order. Everyone is speaking everything.
Where is the?
Kindly come to the order, madam.
Yes.
Madam, kindly come to the order.
ও
দেখা
বলো
order. কত পেজ বলো?
Very well, let the advocate-
Page
let
159.
us hear the matter. Let us hear out the matter. Let the reports come before the court. The
তো এই রিপোর্টটা
this is on behalf of the petitioner
দেওয়ার কথা আছে।
that the petitioner has
স্টেট দেবে না রিপোর্ট?
State দেবো।
challenged the
হাইরিস চ্যালেঞ্জ করেছে
on
বলে
the-
লিগালি
My lord, now I may not want to file report, but Advocate General will file report.
Yes, yes,
Only
yes.
for Akita. For that is my lord.
Files of the West Bengal sand mining policy, 2021.
if they have challenged the virus, then the entire legality of the my lord,
That should be decided first.
that has to be decided first.
Yes.
So, my lord, in that event, the report did not be filed, my lord, because
Before that.
No. Let me fix a date for hearing.
yes.
An accommodation is sought on behalf of the learned Advocate General. Paragraph, let the matter appear. When can you come back? Appear under the same heading on 8 February.
Lordship, 6 to 15, actually, Lordship, I have on arbitration matter. So 6 to 15 February, then any other date, Lordship. No, Chennai. 16.
Since June 2023, I came before Lordship. I have been, by this process, the hearing of the matter is being delayed for on, kindly see, my lord.
Yes, because you've challenged the virus.
Here, my lord, that does not mean that it will be delayed.
Then before 6.
You also made
I will be denied justice by this way. Only your lordship can see. I have deposited 2 crores. They have received 2 crores.
My lord, so
And I am not in a position to
understanding of
kindly
law,
allow
my
me.
lord, if
Mr.
he
Kamath,
wants-
Allow me.
Mr. Kamath, it is on the personal ground of learned counsel, not on the ground of the parties. He will not. be
I am ready to do this. Sir.
if
I am-
the
only I am
wants to
paying my-
challenge the virus, he has to challenge the
16
virus
February, please come.
entirely, my lord. But here, my lord, he is unsuccessful in the appeal. That's why he is saying that
Yes. Yes.
particular memo is
Yes, I have to say yes. I
is
may be
not-
wrong.
is
That
wrong,
will be-
my
that-
lord.
that will
That
be-
he cannot, my lord.
I may be wrong. My submission may be wrong.
It has to be considered.
It will be decided by the court.
Come back. Let it be decided.
একটা পিটিশন লেখো না দিয়ে এসো তাও থাকবে।
Next.
My learned senior my lord appearing at me.
No, my lord,
Respondents.
For the state. From the state.
whenever a persons appear before your lordships, my lord, rather before the honorable court, they always come to have a justice. Now, my lord, question is my lord, is it a genuine case? My lord certainly can put it, because in the name of the justice, someone actually coming with an intention to do injustice to the others. Now, my lord, here is very peculiar. I am admitted the owner of the property. Owner of the property. There's a doubt and dispute over this. And I started my construction in the property. Now, certain portion of the property that was acquired by the government, let them acquire. Legally, I never challenged, nobody has challenged. It's all right. So prior to that, entire land, I don't have any problem to use it. There's an access. There's a link road and then high road. So my lord, so for others, they're also using the same thing. My lord certainly asked me the question, we are taking the name of the others because the way an obstruction is created by the concerned respondent, my lord, just in front of my land, a 13 feet height wall has been given to block everything. Not other is not affected, it's a vindictive. So my lord, I just requested the DM and other authority, sir, this is the position, kindly consider this aspect. Where is my access? DM was kind enough to say the sub-division officer that will make an inquiry. Nothing was done, which compelled me to come before the lordships. Naturally, there are total inactions. My lord was kind enough to pass the directions, as it appears from the order, that well, there is an inquiry.
Nice thing, survey inquiry. My lord, they inquired and they filed a report. My lord was kind enough to grant me an opportunity to rejoinder of the report. Here is the rejoinder. It's a very peculiar thing. The basic and fundamental thing is this. Dao bhai, oye, kothay geli? De bhai. That is the rejoinder. And my lord is surprised. Exception is, my lord is surprised to note a person who is affected, who will be affected, whose right is prejudice, he was never been served any notice. And behind my back, that was done. Is it permissible? My first question to my
The inspection.
my lord, inspection, inquiry, whether there is an alternative route or not. So who is the person to say best? Who is the person who can show there is no alternative road? But I was never been informed. I was never there. No notice was served. And that inquiry is very peculiar. I'll place it, my lord. Land which doesn't belongs to me, that belongs to another hotel. But there is road. There is road. But how can I use it? I cannot. Because he's
The hotel belongs to you?
no. I'm grateful. Very right question, my lord, putting my lord. Of course, court is always putting the right questions. Now, my lord, it is not my land. Kindly see the report, my lord. First, I'll place the report, my lord. Have you also got it, my lord?
Yes.
District Secretary on Land and Absorption Code and submit as follows. That I am the authorized person by Resolution 4 in the writ petitions. Resolution 4 kya hai dekho. Writ petitions. I have made acquainted with. I have made acquainted. Additional Resolution 4 is additional distinguished. I have made acquainted with the facts and circumstances. So this is not today's knowledge. Acquainted of this case after going to the records, and hence I am conversant with the facts and circumstances of the case in such case. I am competent to sanction. As directed by the Honorable Court on such and such I state under. In compliance of the order dated such and such, passed by the Honorable Justice SUVRA Court in disposing the such and such, Joya said versus such and such, I am submitting herewith the report as sought for by the Honorable Court with request to submit the same. An acquisition proceeding was initiated wherein 7 decimal plot of land portions was acquired, including other lands for construction of an administrative building out of the total land of the petitioner. Can you mark it, my lord? Thereafter, that means entire land, there is access, there is no problem. Then respondent authority started construction of the boundary wall, but the petitioner alleged that the respondent authority obstructed the ingress and egress of the petitioner to. I oppose consciously, my lord. I was not even served notice. Obstructed the ingress and egress of the petitioner to go the link road connected to the national highway. Subsequently, the petitioner made several representations before the respondent concerned, requesting them for keeping a space open for entrance to the plot number 410 and children such and such, that after receiving the said representation, the respondent authority stopped the construction of boundary wall consciously. They realize wrong has been done. Cause the boundary wall for the time being. And in this regard, answer the estimated Purva Mednapur road to the subdivision of inquire. But that inquiry has never been done. So they stopped that construction because the DM received the representation. He requested the subdivision officer to inquire and file a report. Photocopy of the said letter. The blocked land 1, land reforms officer, Tamluk 1, Purva Mednapur made a joint inspection. Can you mark it, my lord? On such and such day, in presence of the representative of the irrigation department, Tamluk, and the DPL of Purva Mednapur. Kindly see. No notice was served on me. Mednapur, at the field, the inspecting team found that there is an existing ingress and egress on the front of that hotel, namely Raj Hotel, and the proposed boundary are going to be erected at the back side of that Raj Hotel. Kindly marked it. Very rightly, my lord, put these questions. So Raj Hotel belongs to whom? Third party. I don't have any connections. Photocopy is such. A joint field verification has been conducted on Saturday by the Deputy Magistrate Tamluk, Block Development Officer Tamluk, and the such and such revenue officers of the block. The inquiry team has found that the field position as mentioned in the earlier report has remained same till date. Thereafter, the sub-division officer Tomluk division submitted an inquiry report to the district magistrate Provendapur, which was made on the basis of the such that sub-division officer, in comparison of the direction of the district magistrate, previously no action was taken. Then he filed a report. Let them point that in view of the fact said above, it is crystal clear that the allegation level against the respondent in this instant petition are vague and has no basis. Therefore, this instant petition should be dismissed and such. Now, kindly come to my exception. And kindly take trouble to his annexures. Contable first. Kindly take trouble to come at page 6, my lord, just once, my lord, of this report. Page 6. No, page 6, the letter. Page 6 of the report. I'm sorry, report. I'm sorry.
Yes.
Enclose, please. Find here is the petition submitted at public convention given district magistrate Purva Mednapur by Sira such and such and such and such and such. Who should speak for itself? You are therefore requested to inquire the matter and take necessary action at the earliest, and also to send your ATR to the such. Nothing was done. Nothing was done. It was kept pending. So naturally, I had no other authority but to come before lordship. That is why I started with this. I wanted to have the justice. Now, very peculiar sketch map is given. Can you mark it, my lord? Lordship will not understand anything from this. Not acquired. Yes, this portion, why it is dark, I do not know. Nothing will appear from the report. And it's very hazy, and this report they relied on. Now, kindly take trouble to exception, my lord. Just one, the exception.
Yes.
My exception. Have you also got it, my lord? I, Joya, said, wife of she, all of what said. Then, page 2, para 2. Have you also got it, my lord?
Yes.
With reference to paragraph 2(1) of the said report, save and accept whatever matter on record the statements are such therein. It is submitted that the Honorable Justice SUVRA GHOSH was pleased to call for a report from the respondent in terms of the order and such for disposal of the petitions. It is admitted that an acquisition proceeding was initiated for acquiring 7 decimal of land in part number 410 and 36 decimal of land in part number 411, and the remaining portion of the land measuring about 28 decibels and such within the police stations, district Mednapur, is in our possession, wherein concrete road was there. Can you mark it, my lord? Wherein concrete road was there, and we have constructed a building after getting permission from the Purva Mednapur Jila Parishad by showing concrete road connecting the national highways and such. That concrete road was not done by us, but Jila Parishad road. Then I manage the photocopy and come to that. That while peacefully enjoying such road, all on a sudden, the respondent authorities have obstructed our ingress and egress to go to the link road through the existing road, which is connected with the national highway, and also the bus stand, which is situated almost 20 to 40 feet away, by making construction of a boundary wall, and the said boundary wall has been constructed on plot number such and such only, leaving aside other plots, and the height of the boundary wall is about 13 feet. It is submitted that, well, I am in the IRS. I am not a dacoit or thief. So 13 feet. It is submitted that with regard to the letter issued by the district magistrate, addressing to the sub-division officer Tomluk to inquire into the matter, we have no knowledge about the same, since no copy of such inquiry has been brought to us. With reference to paragraph 2II of the said report, 7 except whatever matter on record, the statement made therein denied. It is submitted that I have no knowledge about the joint inspection. Kindly marked it, my lord. I have no knowledge about the joint inspection made by the block land and land officer. Tomluk 1, the representative of the irrigation department, Tomluk and DPL Purva Mednapur, and the said inspection was made in our absence without serving any notice upon us and upon wrong field inquiry, or plot number 409, stating that there is an existing ingress and egress in the front side of the Hotel Raj, and the proposed boundary wall is going to be erected at the back side of the Raj Hotel. It is submitted that there is no ingress and egress to go to plot number 410, 411 on the front side of the hotel Raj. Can you mark it, my lord? And the said hotel is situated in plot number 409 along with other owners. Can you mark it along with other owners? Namely, Naran Maiti, Shamsundar Das, Pankaj Dinda, Jamaluddin, and the petitioner have no. And the my lord rightly put this question.
Let there be a further joint inspection in your presence.
And my lord,
Otherwise, the problem cannot be sorted out.
absolutely correct. And my lord, what I'm begging, my lord, these are all biased officers. Kindly say appoint any other independent persons. If I lose, I lose. See their district magistrate. See their conduct. In spite of the district magistrate, nothing was done. When he came before lordships, my lord directed that the inspection. It is clear that person will affect. He should be served. He purposely avoided. And kindly see my just one, my lord. Last annexures. Last page.
Yes.
I've given a clear picture. Have you also got to its color? 410 minus C. The red color 410. And there was an existing passage. Boundary wall just touching my property. And then 411 is there, partly acquired on the right side. Can you see my? Let them accord. I'm not disturbing them. And both the entry and exit that has been closed purposely motivatedly. And 409 Hotel Raj. 409, 409, 409, 402. That is their road. I don't have any access there. And one funny thing is this: suppose today, my lord A and B, they have got their own adjoining land. Now, my lord, if there is an enmity, hostility, they may say, no, I will not allow you to use my land. My lord very rightly put this question: Raj Hotel belongs to you. If it belongs to me, I am out. I realize why my lord put me this question. It's a third party, and I don't have any access.
Because in the report, there is a document which says that you have made a submission that Raj Hotel belongs to you.
Yes.
In the report.
Yes.
Yes. It's 7 of my lord.
In this report.
Yes.
On the other hand, if I do not appear, how can I submit? I'm really, because specifically I have stated.
Page 7 of the report.
Page 7.
There's a letter, the second paragraph.
At the field inspection, team found there is an existing irrigation on the front side of the Raj Hotel.
Before that, the paragraph before that.
Before that.
In
his application, the petitioner stated, increase and increase towards the hotel construction over plot number 404. But my plot is 410, 411.
This is also 410, 11.
No, 409. Kindly see.
That's your sketch map, but please see this document.
Kindly see the case match. Kindly see the case match in my exception.
I've seen the sketch map.
409.
This document also refers to your letter. That's why I'm asking.
My lord, I've never said if I want to construct a hotel 411, that's a different thing. But Raj Hotel 409.
See this second paragraph, page 7.
Page 7. I'm reading my letter. In this application, the petitioner stated that the ingress towards the hotel construction. Hotel construction 410, 411. Raj Hotel has got nothing to do. 11. Moses answered will be hampered due to proposed boundary development. So the Raj Hotel is running, belongs to others. And I want to make a construction.
Construct a hotel in this.
401, 402, 410. So kindly appreciate this aspect. I got very rightly, my lord said, I got understood. If I say Raj Hotel belongs to me, I'm out. But suppose today, if I make a construction for the purpose of running a hotel, very well. But that doesn't mean that hotel belongs to me, because that hotel is at 409.
Let us hear the government, because I think a fresh inquiry is required.
Yes.
The joint inspection has been held in as soon as the petition. It is true, my lord.
Yes.
Let the authority be directed to fresh, my lord, joint inspection.
A fresh joint inspection in presence of the petitioner.
Yes.
And by the GC,
And the matter will be pending.
yes, certainly, my lord. I must frankly confess, my lord, I didn't, hey, it is sorrow, I must frankly go hide and seek. I didn't notice that, but after going to this, I found substantial corrections. Had it been a case, Raj Hotel in plot number
409.
409.
You want to construct in 410 and 411.
Ah,
And they have combined the both and they've stated that there is no obstruction. Exception used by the petitioners to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph. It is submitted on behalf of the petitioners that the joint inspection held by the block land and land
Yes, my lord. Block line is the
by the block land and land reforms officer
But it's not clear.
Tomlu was behind the back of the petitioners and no notice of such inspection was served upon the petitioners. Stop. Learned
it is also evident from the report that no notice was served.
Learned counsel takes this court to the report in the form of affidavit submitted on behalf of the respondents, which reflects that no notice of the joint inspection was served upon the petitioners. Stop. Also, comma, the report indicates that there is existing ingress and ingress on the front side of a hotel, namely Raj Hotel, and the proposed boundary wall is going to be constructed at the back side of the hotel. Stop. The petitioners intend to construct a hotel in plots number 410 and 411 as recorded in the letter dated 1st June 2023, and nowhere is it stated that the petitioners are the owners of Raj Hotel already in existence. Stop. Therefore,
instruction
pre-egress and ingress from/to Raj Hotel, from/to Raj Hotel is irrelevant insofar as the present writ application is concerned. Paragraph. Learned counsel for the respondents also submits that the inspection was held without service of notice upon the petitioners. That is on record.
That is on record.
Paragraph. In view of the above, comma, this court is inclined to hold that since the petitioners allege construction of a 7 feet wall,
13 feet. 13 feet.
13 feet wall
Only blocking our
adjoining their
land.
plots, comma, thereby blocking the only egress and ingress, comma, the concerned authority who should hold the inspection.
My lord. No. Let the
DM take necessary steps.
Yes.
That can monitor DM.
Being the third respondent herein, be directed to take necessary steps for holding a joint field inquiry in this regard in presence of all concerned, including the petitioners, and submit a report by the adjourned date. Paragraph. It is made clear that the joint field inquiry shall be held in presence of all the interested persons, including the petitioners. Paragraph. Let the matter appear under the same heading on 1 month.
This month.
My lord, less than 1 month, they can do that.
Don't
Make it 3 weeks, my lord.
12th February.
As my lord very rightly put this question. I know who is pulling the thing sitting behind this. It is the Raj Hotel. They are actually, my lord very rightly put. I'm grateful, my lord. Deeply obliged. May I leave, my lord?
We shall file report in the form of affidavit. We shall file report in the form of affidavit.
Yes.
For the petitioner, for the petitioner, it's a land acquisition on the National Highway Act. There was supposed to be a report, your lordship.
But I am for the state, my lord. But although I have received the instruction, my lord, kindly allow me some time to file it in the form of affidavit. What I received is that my lord, they have received the awarded amount. Oh, report file করেছে না একটা একটু ডিল করে নি আমি একটু সময় নেব ওই point they have received the awarded amount, not the arbitration held, my lord. He says he didn't participate, but that amount was also paid to him. So our submission is that
But did he participate? That's
I'll on that particular point, but I'll.
Simple case, I'm not disputing. It's an oath that I have been accepted the amount. The amount has been paid. The question is when the 3G1 was there, because I have got to, because from item 13 to 17, the similar point of law is involved. So I've got to reports from my senior friend, but it doesn't disclose the date of the award. That when they've given this award to me. And my case is if the award has been paid after 1st January 2015, I'm entering the new act. And so that is the question which has
No,
to
his
happen.
remedy would be before under section 34.
No,
But before that, I'll.
Arbitration. My instruction is that let them produce.
I must want to.
Yes.
Your lordship, they are only 13 months. Not.
Oh, they are in 13.
Yes,
Very
my
good.
lord, only that.
Oh, 14 you are ready.
Yes, my lord.
14 is ready. So let 14 be taken.
Let 14 be taken.
Let
My lord,
14 be taken.
item number 13, my lord, I am ready to, as per lordship direction, lordship, I am ready with my report, lordship.
File your report.
Our
So
copy.
13 will be adjourned for the
But
report.
13 may be adjourned, but I'll.
For the report.
On this particular point, not whether.
Lordship, let them
He
give
was.
advance copy because the NHA is giving report in 13 to 17. I'll use my exception in all of them, your lordship.
Lord, I am appearing in the 15, my lord. I want to file report in the form of affidavit, my lord. Because petitioner, as per my instruction, my lord, petitioner is
I'll
not
call
entitled.
15. Please wait, I'll call 15. I'll call one by
That
one.
it is mentioned, that's why.
I'll call one.
15 and out, sir.
13 total. 13 in report in the form of affidavit submitted on behalf of the National Highways Authority of India. It's taken on record. Paragraph learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 7th February.
7th February.
Please serve advance.
I shall.
Let the matter appear on prayer of the petitioner. Liberty is granted to use exception to the reports.
14 টা নীল রতন
14.
স্যার আপনি 14 টা
Yes, 14, Mr. De.
But in my lord, I filed the report, man.
I've received a report copy.
You want to use exception?
Yes.
my lord in item number 14 my lord
Mr. De, the petitioner wants to use exceptions.
Yes, my lord.
Because it doesn't disclose anything, I'll use exception.
Report in the form of affidavit submitted on behalf of the National Highways Authority of India is taken on record. Paragraph, learned counsel for the petitioners seeks to use exceptions to both the reports. Paragraph, same date. Let the matter appear under the same heading on 7th February.
নীল রতন সরকার একটা দিয়েছে আমাকে প্রথমত 13টা দিয়েছে for the petition.
কি নাম কো 15
You want to file a report?
Yes, my lord.
15 এর নামটা কি
I have received the report, but that is not sufficient, my lord. I need further.
কি নামটা দেখ না রে বাবা বলতে না কেন এগুলো
Please ensure that the date of award, payment of award is there in your report. That
All
is
right,
the
my
crux of the matters, all these matters.
Yes, your lord.
All right, my lord.
my lord in item
My lord,
number 15
my lord, all the report, same report.
Yes.
My lord, all the report, there is a specific
he, on signing of the things, my lord, that he take the 3G1 and 3G5.
Yes. Maybe,
Three
but
G
still
one,
it's entitled.
3G1 before 14, before 2014, my lord. So he has not entitled to get the, now, my lord,
Before 1115.
arbitration amount, enhanced amount also received by the petitioner, my lord. In my case.
My lord,
In
this
every
is
case,
our,
my
in
lord,
every case, lordship, this is our submissions, lordship. After receiving the compensation, his remedy before the section 34, my lord. That is the case of every time, lordship. This is our submission is every occasion.
Your lordship,
After objection.
Ashok Chuan হয়ে গেল।
but they can't raise this point, my lord, that he can't never receive the, my lord, the 3G1. How he file or anything else, my lord, how he get award amount? If he receive, my
3G1
lord,
is not disputed. You have
No.
received both the awards.
Now your lordship.
both the awards he received, my lord.
lordship, the
Now he has
process
come
already-
to
Yes.
challenge that I am not getting the.
My lord,
3G1.
Well, arbitrator
blow
already
hot and
enhanced, my
cold
lord.
at the same time, man.
On
It
that
blow,
point.
it is cannot blow hot and cold at the same time. This is our case in several.
Your lordship, difficulty, the 3G1 has been paid.
Now when my lord, it has
What is
come
the-
to
what is
the
the
lawyer,
practice
my lord, a new
What is
case,
the
my lord.
What is the practice being done is, initially when the check was
No
issued,
practice.
it was a physical copy.
নিয়েছে।
Now once the 3G1 they are paying,
Compensation নিয়ে
what is
নিয়ে
the
arbitrator
something
enhanced।
you will have done.
এটা
They
enhance
have, because
করেছে
the
এবং সেটা
limited
নিয়ে
statement is there, your lordship, I have to participate in the process.
Absolutely.
They have to serve me a notice. In the bottom of the every award, let them produce the arbitration award. It is written, it is applicable to all the land.
Of the entire moja, yes.
That cannot be the
My
case.
lord, he can't challenge that. As because my lord, he took the award, he first said, give me the 3G1. And now said, give me the 3G5.
3G1 is not
My lord,
understandable.
it is his duty, my lord, to file an application before the for certified copy of 3G5. After a long period, my
No, your
lord, he
lordship.
has come before the honorable.
Under section,
He participated in 3G5.
My lord, that
Yes, my lord.
participation, my lord, he can file an application before the certified copy. That is the procedure.
মানে already
My lord, the amount must be-
Participates.
my lord, he,
my lord,
when
arbitrator has enhanced the compensation, he has accepted, my lord. As per my instruction, my lord, he has accepted, my lord. And he has arbitrator,
He has accepted, madam. Have you served notice of arbitration to the
my
petitioner?
lord, I will produce
Has
by
the
in the
petitioner
form of.
participated in the arbitration? If he
All
has
right,
not, he can challenge the amount before this court. 34 is
My
not.
lord,
Yes, ma'am, that's true, that's
law now.
their lawyer, my lord,
After receiving the compensations, my lord, he has my lord, this is what about lordship? The arbitration is all about lordship, the enhancement. Well,
Aye.
arbitration proceeding is all about lordship, subject to lordship's correction. Lordship, it is all about for the enhancement of the compensation after receiving any grievance, lordship. Lordship, now lordship has been functus officio, lordship. After the arbitration proceeding, his remedy before the section 34, lordship.
Only after he participates, not otherwise. There are several judgments. He has to
That is the
participate, he has to
judgment.
serve notice of 3G5. Otherwise, he is not bound by the order.
Lordship, in lordship, my humble submissions, lordship, if he not received the compensation, lordship, but lordship, he has accepted, lordship, he received the compensation, lordship.
After objection, that doesn't decide entirely. Anyway, we'll hear of the lordship. There are several judgments on this.
your lordship at least have to be allowed to participate.
Yes, yes. A report in the form of affidavit submitted on behalf of the National Highways Authority of India is taken on record. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 7th February, same date. 7th February.
Deeply obliged, my lord.
No.
My lord, I am led by Ashim Kumar Ganguly. He is in court number 654.
Next.
Second কি আছে বলো 16 টা
16, Mr. Bhakti. Report submitted.
Yes, my lord, I am already.
I am filing my report.
I have received a plain report.
আগেরটাতেও করুন, the learned counsel for petitioner seeks to use exceptions to the reports. তারপর let the matter appear. এটাতেও তাই করুন, report submitted on behalf of the National Highways Authority of India is report in the form of affidavit. It's taken on record. Paragraph, learned counsel for the petitioner seeks to use exceptions to the reports. Paragraph, let the matter appear under the same heading on.
আরে হ্যাঁ স্বাভাবিক গুলি যাচ্ছে তো
এটা নেই বলছে আমাদের এই আজকে লিস্ট করবে I for the petition.
I am for the state, my lord. I file the
I am filing. Reports in the form of affidavit submitted on behalf of the state respondent and the National Highways Authority of
Your
India.
Lordship,
are
state
taken on
hasn't given
record.
an affidavit, it's a plain
Oh,
report.
this is a report, huh? Report in the form of affidavit submitted on behalf of the National Highways Authority of India and status report submitted on behalf of the state respondents are taken on record. Paragraph, Learned Counsel for the petitioner seeks to use exceptions to both the reports. Paragraph, let the matter appear under the same heading on 7th April. Please serve advance copies.
তুমি বিপ্লব কোনটা রেখে দাও কারণ আমার আবার গোলাপি
আচ্ছা তুমি সঠিক লিখিয়ে দিচ্ছ
I appear for the petitioner. Pursuant to lordship's direction, they are served as a copy of the exception, their report.
Yes.
They gave us report. We have also prepared
I'm
our
filing my
exception.
report, my lord.
You wanted to use an exception, are you ready?
Yes.
I have not read.
For the
My lord,
private respondent, the respondent number 9, my lord. My lord, on the last occasion, my lord, I believe the state authorities had submitted a report. My lord, we have not received a copy of the report yet. My lord, if
Copy please.
আমরা দিচ্ছি
I am the private respondent number.
Yeah.
yes private respondent
I am MH colleague, sir. No, it was sent to them, my lord.
My lord, I apologize.
It was sent to his client.
It appears that there is a communication that it was sent to me, my lord. However, my lord, my instructions are
We shall
that
supply
haven't
another
received
copy.
it yet. If I get another copy, my lord, upon perusal of the same,
It has been sent to them. We shall give another copy. At a
Lord,
copy of the
with liberty to file exception if necessary.
The report contains certain documents. এখন না বলবো না, ওরা বলুন। Then should we wait for his exception or not?
Yes. He needs to go through the report.
Property nature and character যেন চেঞ্জ করতে পারে।
My lord, in the meantime, our case is that we were in possession till 2023. Their case in the report is that there was a BR case, land was vested. Nothing more, nothing less. Only on the basis of an endorsement in the register 8, that BR case noting is there. Nothing, my lord, disclosed. Nothing disclosed. In normally, my lord, in BR cases, my lord, the landowner is entitled to, my lord, exercise his choice. Nothing is disclosed.
In a
My
roundabout
lord,
way, they're
let-
challenging
let
the
them-
vesting now. I have stated.
No,
I have also
vesting-
given them a lot record of right, which records the BR case.
It
and
is
vesting.
noting.
They're challenging the
Any
vesting now.
person or any officer
Roundabout.
can note it down that is BR case is there.
Interim order at this.
But Tom, Dick, Harry, any person can note it. But there might be.
What is your prayer in the writ petition?
My lord, it was conscious. My lord, my interim prayer, my lord, was that not to, my lord,
Setting aside the writ of possession.
yes.
Where is the writ of possession?
My lord, that is at page 36.
We have given a long-term settlement in favor of the private respondent.
Provided it is vested.
For the possession of Asanaki.
Yes.
They are in
Provided
possession.
it has gone to Khotian number 1, collector's Khotian. That is why.
চাইতে পারতো এক্সেপশন রিপোর্টটা।
It says possession has been handed over to the private
To the private
respondent.
respondent.
How could it
On
be?
the basis of a
I
long-term settlement.
was in possession.
But what is the basis of this?
Yes.
The vested land, a long-term settlement has been executed in favor of the private respondent. On the basis of the long-term
The
settlement.
vesting order is there in your report?
Yes, I have stated in the report, my lord.
Report, my lord, on the basis of some noting in the register 8, PR case.
In that case, you have to challenge the vesting.
Yes, my lord, unless we get the entire record, my lord, to get inspection of the entire record, or let them produce the entire record, my lord. Kindly, my lord, direct them. Otherwise, my lord, I will be deprived of my all right title in.
I am afraid it will not be done before this court.
Not in this.
No, my lord. But at least, my lord, I have the right to inspection, because once they take the point that it is a, by virtue of a BR case, it has
Since
been
the
vested.
matter is it stands on the anvil of a vesting order, this court will not have jurisdiction to deal with it at all.
No,
It's
my
the
lord,
land
I'm not on that. I am going far to the root of the case. Because of the noting BR case, only BR case noting. My lord, by that, my lord, noting, my lord, my right, entire right will go. Let them produce, my lord. What I am
to
praying at.
establish it right, you have to challenge the vesting. The state says the land is vested.
And separate Khotian has been annexed to the report. Kindly see, my lord,
saying that
page
that is
7.
vesting.
Document.
It will
No,
include.
page 7 is the document.
Page 25 of.
Page 7 which records, my lord, the vesting and separate Khotian was created in favor of the collector.
My lord, kindly see page 25 of my writ petition.
Document is otherwise, their own document.
It is their own certified copy
Kindly
supplied
7
to
and
me.
8, my lord, all their recordings are struck off.
My lord, kindly see page 25 of the writ petition.
Rayati Mokar is sitting on, what is the date of this?
When was this issued?
My lord,
The vesting is after this.
No, vesting was in 1971.
Prior to this.
14/2/71 is the date of effect.
Of 96. The 96.
The record was not corrected.
No, no,
what I want
same
that, my
Dagnama,
lord.
no, record was corrected. Same Dagnama, my lord, separate Khotian, a portion was vested. So far as the vested portion, my lord, separate Khotian
My
was
lord,
created,
everything is based
and
on.
unvested portion, Khotian remained in the name of the Rayat.
No, but page 25 is the entire portion.
Yes.
No, no.
Page 25.
They cannot take advantage of their
Their own wrong.
It's Sholana.
96. Yes. 1996. Rayati Mokar is Stitiman Shattu.
They must come up with before the court with clean hands with the particular documents, with the records. Everything must be specific.
Now, subsequently, as an afterthought, noting on the basis of.
No, not an afterthought. These are old record. I have annexed my original records. It's
Cannot
already
be
the
afterthought.
document
My
record
lord,
cannot be afterthought, my lord.
These are records.
Only
copies of
thing,
records.
only their basis of their statement that the land
The
is
court,
vested.
this
Your
court
lordship.
at least cannot call for vesting records.
No, I am not on that, my lord.
Then
Since
you are
they
not
have,
what?
since they have come up before your lordship with a stand that the land has been vested, they must come with clean hand to your lordship
Where
to
is the
say
argument?
that, yes,
how
this
is
is the proceeding. There is no proceeding case number even, only
Have
we are
given. It
noting.
is there, my lord. Kindly come to page
They are
7 of the
noting only.
report. It is there.
We are noting.
7
Will
of
you?
Kindly see page 7, my lord. Kindly see, my lord. It was initially Shital Prasad Singora. His name is struck off on the left side. Kindly come to right side, my lord. অত্র খতিয়ান ইংরেজি 14/2/71 পর্যন্ত বলবৎ ছিল। Then BR case number 59 or 79. So mention the number also. They have to now apply for a certified copy of the BR case and challenge it before the appropriate forum. When it is disclosed.
How it could be, my
Presumption
lord,
is that not
if-
official
if
records are kept in due course.
If in
The BR
1996
case
they
records
give us.
cannot be called for by this court. I'm sorry.
My lord, only thing, my lord, kindly consider, my lord. Because of this, my lord, page 25, the certified copy was given to me in 1996.
It is the record of rights.
Yes, record of
So
rights.
if there is a wrong
It is,
recording,
it
of
is
the
from
record
the,
of
it is from
rights,
their own record, not that,
yes,
it is from their own custody.
I understand, sir, but if it is a wrong recording according to them, you have
Hello.
to still challenge the vesting order.
My lord,
The basis is the vesting order.
the basis is that we are noting. We are noting.
This is the record maintained by the state respondents, which I have disclosed. Now they have somehow procured one record of right in which Ak Angsho is shown. So they say this. So that not they have to take this point before the vesting
No,
also,
no, no, no.
because wrong recording will not confer a right. If you can show that the proceeding was lawfully done.
If there is vesting, my lord, they should come up before your lordship with clean hand, producing
Let them make an application before the
Court doesn't
authority.
have the jurisdiction to call for the records.
produce them, at least they should produce the, what I am on, my lord. At this stage, my lord, let them, my lord, produce the records of the vesting.
Court doesn't have the jurisdiction, sir, to call for vesting records.
Then on basis, if on the
The
basis of the,
moment it appears that this is a vesting proceeding, the court will not consider it any further.
my lord,
I have to release the matter.
sitting in the read jurisdiction, my lord, this is my humble
Specified
submission.
act, read jurisdiction.
There is a bar of jurisdiction.
My lord,
Section 8, there is a
Can be
bar.
entered by the division bench, not the single bench.
Once a party to a proceeding takes a particular stand that the land is vested,
The
then, my
matter
lord,
immediately goes before the appropriate forum.
my lord, they should, my lord, at least they should give some documents to show that, yes, it is vested.
The appropriate forum will deal with this, not this court. I have to dismiss it on this point, on the ground of jurisdiction.
My lord, the only thing your lordship kindly see what they have stated in page 7 of the report.
Yes. Page 7,
Yeah, page 7 of the report.
yes.
সেকশন 4(4) ধারা মতে প্রযোজ্য অত্র খতিয়ান পর্যন্ত 24/2/71 পর্যন্ত বলবৎ থাকিবে।
And name of Shital Prasad was struck off. Kindly see on the left side. Shital Prasad is struck off.
BR case number 79.
Yes.
একটা জিনিস এটা দেখা
Shital Prasad
Kindly take note of that, my lord. The noting is of case is of BR case number of 79. 59 of 79.
Yes.
And it was attested in 76, just left side, just left side. Attested in
You are
76.
again challenging the record of rights. I do not say that you do not have a case. You may have a case.
No,
but
I
this
am
court
not.
does
I am not on
reduce-
that. I am saying that these are all, my lord. If I am permitted to say that, it is all, my lord, afterthought. Because, my lord, it is, if the BR case is of 79, how it could be attested in 76?
Yes, Mr. Banerjee. The attestation is in
That is what the revenue officer. I can
Yes.
explain that kindly. Then give me. Okay, take up on the next week. I'll satisfy this because initially it was in the name of Shital Prasad. That's the old record. Then my lord struck off in the same page, strucking off, and subsequent recording was done in the same page. So there would be my lord several dates. Original was Shital Prasad. Lordship will see that was prior to 72.
The certification.
Prior to 72, 71.
You know the BR case
Yes.
number. There's a signature and a date.
Attestation
on
fine,
20th October 76.
Attestation was done, my lord, because this record was maintained prior to, my lord, the vesting. So it was in the name of Shital Prasad. Then the vesting took place in 79 case, 59 of 79. Then, my lord, the name was struck off. So there are two dates. This is what appears from the record, but I'll take specific instruction on this. Why 76 was mentioned? I'll take.
I don't think the matter needs to. It'll be only a waste of time if it continues in this court.
These are points.
Instead of wasting further time, I would request you to approach the appropriate forum.
My lord, kindly, my lord, take him, let him, my lord, take instruction. Why this has been done? If the case is
clear,
so that we can be, my lord, sure of our stand to be taken in the appropriate forum.
Even if you're challenging genuineness of a record of rights, this court will not have the jurisdiction.
I am not on the record of rights. I follow your lordships. For the
When
purpose of record of rights, I have
Aware.
to take.
You
no doubt.
are aware, sir.
I-
You are aware.
my lord, But
Any matter under the specified act, I cannot deal with it.
if the doubt emanates
in case
from
of
the
doubt,
record,
then
the
also
doubt emanates.
Section
my
8
lord,
is
it
a bar.
it's their own burden to clear that.
Not before
How
this
it can
forum.
be?
Not before
Yes,
this
yes,
forum.
yes. Before your lordship in this forum, you have produced a certain document which, my lord, emanates some doubts in the mind of the court even.
This document was issued prior to 1971. According to the
BR
document,
case number is 59 of
this
1979.
was valid till 71. That is the recording
That
in
is
the
the
document, right?
Then BR case
Lord, then
79.
also will not an inquiry
Then how
into
could
this
it be? If it
document
is 71 valid,
means an
if
inquiry
it is
into the
valid till
specified act.
71, if it is valid till 71,
So that is again an anomaly in the record of rights which
Record of
this court and
Correct, sir. This is in Bengali vernacular. This is
The
79.
doubt will not confer jurisdiction because there is specific bar of jurisdiction in section 8.
1 and 9 looks the same, sir.
79.
It's also-
79, ma'am.
BR case 79.
This is the point to be taken in the vesting proceeding, not before
It
this.
was in force till 71, Bollywood Shilo.
Yes, that is
Even
not
if it
clear.
is prima facie held that this document is not genuine,
So, my lord, your lordship, kindly, my lord, direct them to clear this part.
sir,
How it could be,
I
that, my lord,
I have to
why I am,
discuss on this ground.
my lord, I am praying
I
for
do
one
not want to
more
spend further time
indulgence,
on this.
one more indulgence, because, my lord, I have to take steps. I have to take steps as it's fallen from your lordship.
Yes.
But on the basis of these, how can I?
You will have to apply for certificate copy.
No, merely certified copy.
There is a
no.
procedure.
Will not give any further direction to the respondents, sir. This court
No, it is not the question of wastage of time because it also involves my right title interest over my land.
Yes,
I was
this
in
is the-
possession,
I
my lord,
don't
in one
consider
fine morning, my lord, they have come up with an writ of possession. They took my possession. Then, my lord, on the basis of what?
You have to challenge the vesting.
How can I challenge the vesting now? Because it is the case of BR case of 79. Now, it is very clear that in 76, it has been attested. Kindly consider this.
Well,
aspect. Kindly consider this
I will
aspect. Let them
consider the
clear. Let them
limitation
clear
period.
it.
I will consider the limitation period if that is your difficulty. I'll direct the authority to deal with it on merits without dismissing it on the limitation ground. That can be done. But this court cannot pass any further orders, sir. The act itself is very clear.
Kindly, my lord, pass an order subject to your lordship's correction. That how could it be that once the
I
case.
will not go into merits at all. I'll not go into that at all. Even if it is a forged document, you have to challenge it before the authority.
My lord, in that
The
case.
other one cannot be challenged before this court.
My lord, if
I do
prima
not,
facie,
I
it
repeat,
prima facie appears
I
from the
do
record.
not say that you do not have a case. You may have a very good case, but that has to be dealt with by the appropriate authority and not by this court, not by this forum. You may have a very good case and you may win before the
My lord,
authority.
even it is, my lord, even if my lord appears before your lordships, that prima facie it appears on the basis of the record.
That it is forged, I cannot still deal with it. I still cannot deal with it.
Well, let them
forgery
come up,
has
let them
similar
come up,
jurisdiction.
let them come up before your lordships as to how and why.
I
Before-
think I've made my comments. I have to either dismiss or allow you to withdraw. On the jurisdiction ground, I have to dismiss.
My lord, then in that case, my lord, my all remedy will go.
You can approach the appropriate forum. I can grant you liberty.
My lord.
I'm sorry, sir. This court cannot deal with this matter.
My lord, they should, my lord, remove the
Very
doubt.
interesting
They
point of law. I would have been very happy to deal with it, but
No, my lord, what I am on, my lord, I am at the cost of repetition, my lord. They should, my lord, remove the doubt. How it could be possible?
they'll remove the doubt. They have to remove
Before
it
the appropriate
forum. The
Kindly record that, my lord, in the order.
the petitioners, the petitioner has challenged the writ of possession issued against him on February 17, 2023. Stop. In the report in the form of affidavit submitted on behalf of the exception to the report in the form of affidavit, exception used by the petitioner to the report in the form of affidavit is taken on record. In the report in the form of affidavit submitted on behalf of the state respondents, it is stated that the LR Khotian bearing the petitioner's name was in existence up to 14th February 1971. After which, a BR case being number, BR capital, case being number 54/79.
59.
54 of 79.
54. Oh,
Your report
এখানে
says
54.
54.
Report says no.
Report says
4.
Your report says
My
54.
lord.
54 of 79 was
Which one should I follow, my lord?
No, this is 4.
Hmm?
And
the
9.
plots in question were declared vested in the state. The vested land has been subsequently allotted in favor of the private respondent by way of a long-term lease, long-term
settlement.
by way of a long-term settlement. Paragraph the since the present case stands on the anvil of the vesting order issued by the authority, comma, the matter pertains to the West Bengal Land Reforms Act 1955.
As well as estate acquisition, vesting. So far as record of right, land reforms, and so far as not vesting is concerned, estate acquisition.
And the West Bengal Estate Acquisition Act. Paragraph. In view of the above, comma, this court has no jurisdiction to entertain the writ petition, and the same is accordingly dismissed. Paragraph, however, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Stop. In the event the petitioner approaches the appropriate forum within 1 month, within 1 month from this date, comma, the appropriate forum shall deal with the matter on merits and shall not dismiss the same on the maintainability, on the ground of limitation.
Or it may be 2 months because you have to obtain the certified copy of this order.
Within 2 months, 1 month.
My lord, so far as they have to file a section 5, the benefit of not section 14 they will get. Because without so then they will not file a section 5 even and come up with the
Liberty is being also opposed.
so section benefit of section 14 may be given to them. Kindly records that not that.
ওটা কি বললাম?
They will get the benefit of section 14.
Upon the petitioner, should add করুন, upon the petitioner taking appropriate steps before the authority, seeking condonation of the delay.
Yeah.
There shall, however, be no as to costs as in Next. Oh, next. Item 504.
504, I am for the petitioner, my lord. The petitioner has filed a writ application challenging a notice under section 26(2) of the 2002 Act, my lord, by which, my lord, they are going to take possession of the land and, my lord, demolish. Served, my lord.
I am for the Union of India, my lord. Actually, answer.
National has also been
I am now answering respondent. I am not.
This is not the আমার নোটিশটা তো আপাতত ভেঙে দেবে না হলে ব্লাড আই হ্যাভ পেড ফর ডিসপেনসেশন অলসো বাট আই হ্যাভ সার্ভড দ্য ন্যাশনাল হাইওয়ে অ্যাজ ওয়েল অ্যাজ দ্য সেন্ট্রাল গভর্নমেন্ট কাউন্সিল private and everybody. Now, but I've also paid for dispensation because a notice has been served.
Private respondent, anyone?
Private respondent is not the person who has sold the property to us. Notice not is bad because Lordship will kindly see the notice is at page 108.
Service is not complete. It's
Service
item
is not
dispatch.
complete. Blood sub. If we have subbed the national highway also. Lordship see national
All
highway.
item dispatch.
We are
No,
on.
national highway also. This Delhi address.
Dispatch.
Respond number 5 has been served.
Served.
Served personally. Kindly see, there's a stamp of the National Highway Authority. Respond number 5 has been served. Project director. He is the person who has issued the notice. There's a stamp of the project director. Copy, yes.
Where is the stamp of the project director?
Affidavit of service.
Final page 3, my lord. Bottom.
The affidavit of
Page 3 bottom, my lord, at the left hand side. There is a stamp of the NHI, PIU.
Where is Ms. Roy? She can appear in this matter. Oh, Ms. Roy is here. Why don't you appear? I'll regularize your appointment.
এটা হচ্ছে 26(2) নোটিস না অ্যাপিয়ার করনি এখন সার্ভ হয়েছে The notice is at page 108. I'm just not why I'm apprehensive. We mentioned this matter, my lord. Notice is at page 108. The lordship will find, my lord, the Act provides 26(2) that they can serve a notice for removal of encroachment. The rules, Rule 11 says that notice has to be in the form prescribed in third schedule. Third schedule gives the format of the notice. That's
There's
specific.
an opportunity of representation also. Have you
Representation is
filed
there. No, because it was not served in our name, and in our building it was served in the name of Lakshmi apartment. That is, I am on that, my lord. First, my lord, the particulars of the land is not there. Two requirement: particulars of the land and the addressee name and address. Nothing is there in the notice. Kindly see, my lord, address to Lakshmi apartment. Who is Lakshmi apartment, my lord? I am one of the flat owners. Some of the flat owners have come before your lordship.
Lakshmi apartment is the flat.
Is the name of the apartment? Yes. It is not a addressee, my lord. Kindly, my lord, see. Kindly see, my lord, the rules. This notice, my lord, does not conform to the rules. My lord, the rules say. Kindly, my lord, take up, my lord, Rule 11 of the, my lord, Highway Administration Rules. I'll just not hand. Rule 11. Highway Administration Rules.
আমরা বলবো ওই এনেছে বলবো না
বলবো না
Rule 11, your lordship has got. Yes, sir. Highway Administration Rule 2004.
আমরা দেখো
Highway Administration Rules 2004.
4.
Yes.
Rule 11 says every notice to be issued under subsection 2 of section 26 shall be in the form as specified in Schedule 3. Now kindly come to Schedule 3, my lord. If your lordship, my lord, gives this notice beside Schedule 3 form, your lordship will find, my lord, that the requirement, none of the requirement has been satisfied. Schedule 3 says, my lord, I so and so on periodical inspection of highway land on the information received by me, I am satisfied that the unauthorized occupation has taken place on highway comprised of area. So they have to mention the specific area. It is not there in the notice. Then situated at kilometer, they have mentioned the kilometer only of NH number so and so, and such unauthorized occupation has been caused by you. You are responsible for such unauthorized occupation. It says indicate the location sufficient to identify the area. Nothing is mentioned. This is one part. So it is vague. How much encroachment is there, which area, which part, plot of land, nothing is there. Next it says, therefore you, then Lord, name and address of the person to whom notice is to be taken.
Primarily, this is the defect in this.
Yes, Lord. So Lord, these two requirements, none of the requirements.
Notice to the building. Lakshmi apartment is the building.
I have nothing about this matter. I've never came across this type of petition, my lord.
This notice will itself.
Notice will be stayed for because prima facie it appears it's a building.
Without any instructions, lordship, I may be.
I have prayed for dispensation of service.
I'll not record your submission. I'll just stay this.
Lordship not recorded my appearance also.
I'll not record your
Otherwise, my
none appears.
Yes, madam, because I don't even have the copy, madam. I don't have the copy.
Yes, let this notice be stayed. The state will not have anything to do with this.
No.
Who is the
Otherwise,
private
madam,
respond?
give some time, lordship, at least.
NHI is the one.
Private respond is the promoter. The land stands in the record of right, stands in the name of the promoter and his predecessor. Not recorded in the name of the National Highway also. For last 30 years. It is in the name of the, we are in occupation for more than 30 years. We have been assessed, so we shall take these points, but that is not the point today, my lord. We say notice is defective. Next point is, there's one more point, my lord. Under section 23, we can challenge the title of the central government. We have also done that. If that is done, they have to give us a hearing and allow us to produce evidence. That application is also pending.
Let the notice be stayed for the time.
Let them take instance. My lord.
A short stay may be given and let the direction be given for coming with the instruction.
Fine. First data.
Affidavit of service.
Thank you.
None appears for the National Highways Authority of India despite service. Paragraph, the petitioners assail the notice issued by the National Highways Authority of India on 29th December 2023 under section 26 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act 2000. Stop, learned counsel for the petitioners submit that the notice is not in conformity, in conformity with Schedule capital Roman 3 of the Highways Administration Rules, 2004. Paragraph. It prima facie appears that the notice impugned has been issued upon Lakshmi apartment which is an apartment in holding number 75 within bracket 534 bracket closed comma Robindra Polli comma Kolkata 700065 and not on any individual including the petitioners. Stop.
Particulars of the land is also not mentioned. Particulars of the land is also not mentioned.
Particulars of the plot in question are also not mentioned in the notice. Paragraph. Since the petitioners apprehend eviction from the plots in question on the basis of such notice, comma, the notice impugned dated 29th December 2023 be stayed till 31st January. 31st January 2024. Paragraph, let the matter appear under the same heading on 25th January. Paragraph, liberty is granted to the respondents to submit reports in the form of affidavit on the adjourned date if required. Let that be kept open so that the national office also can come back.
A petitioner may be directed to serve the copy of the order upon the respondent.
Yes, I shall
Anything.
serve.
The
That-
petitioner
that-
is directed to serve a copy of this order
একদম, absolute.
upon respondent numbers 4 and 5
4 and 5. Fine.
in the meantime.
Deeply obliged, ma'am.
তারপরে let the last line is on. Next. Five.
My lord, appearing on
For the
behalf of
state.
the petitioner, my lord, for the state. At the time, before the time of the mentioning, my lord, I have served to all respondents, including the state respondents, and item delivery confirm it's showing, my lord. My lord, the petitioner made an application under the Act of 1962 for demolition of illegal construction, page 24.
Service on private respondents.
My lord,
Anyone appearing for the private respondents?
yes, my lord, before mentioning, my lord, I have served all. And this is the affidavit of service, but there is no any confirmation of delivery.
Then how do you say that it is served?
But before mentioning, I have served to all of them, my lord.
Before
But
mentioning, have you served the writ petition?
my lord, I have served, my lord, but delivery confirmed, but drag report does not up to date, my lord.
You have to serve the writ petition and annexure.
Yes, my lord.
And you say it is not complete. You have to serve the, you're aware, sir. You have to serve the private respondents.
I have served to all of them.
Dispatched. Item received. No, these are not service.
My lord, I have a report, my lord, if lordships kindly have it.
Only
Okay, my
the
lord.
state respondents have been served, not the private respondents.
At the time of mentioning, my lord, I have served to all
And
of
there is no track report also of the private respondents.
my lord, there is a statutory procedure before the SDO authority. Let it be
That will
sent
be
to the
heard later on, sir. Please show me service first. You have not even annexed all the track reports.
No, my lord, I have annexed all.
5 private respondents.
Yes, my lord, I have
only one.
I have annexed all, my lord. Kindly see.
You have annexed 4. You have annexed 4 out of 5. Oh, this is Torun Adhikari. All received dispatch, not service. Since service upon the private respondents is not complete, comma, let the matter stand over till 31st January. You can finish complete service. 31st January.
Well, under the heading of mentioned matter.
No, motion. Amlan, under the heading motion.
Well,
Next.
Lordship, I am for the petitioner.
the state.
Lordship, I have served upon the all respondents. I have served upon the all respondents.
The 31st January.
It's the WPMTDCF. Mr. Shah. We wanted to take instructions in this matter.
We have received instruction.
Has the plot already been auctioned and leased out?
Lordship, may I pray? Lordship,
Matter.
in this,
Yes,
It's a land acquisition matter.
land acquisition matter, Lordship. Land acquisition matter. In this matter, I am praying to quash the land acquisition proceeding, Lordship.
দিদি কোন ফাইল দিয়ে দিলেন?
দিদি
কি দিয়ে দিলেন এটা? 20515 দেবেন তো।
0315.
Yes.
Lordship, in this matter, I am praying for quash the land acquisition proceeding and praying for also return the land of the petitioner, which is unlawfully acquired by the respondent authority. And thereafter, Lordship, I am
Who is
praying for
appearing for the private respondent?
Lordship, private respondent,
Prabhuji Food.
Prabhuji,
Your food
Lordship, I have
service?
served, Lordship, I have served through mail, Lordship, because from the net information, I got the address and also mail copy. I have served through mail. Because
serve and come back.
Lordship, Lordship, name of the private I do not know. I got information. We kindly see this last page where the respondent authority. I got some information where the Prabhuji is mentioned, where the land status of the land is mentioned. Prabhuji Pure Food Private Limited. Thereafter, I got net information copy. From I got address of the private respondent and also got email copy. I have served through the email. But Lordship, I do not know pure address of the private respondent because the respondent knows.
420 Kaji Nojrul Islam Avenue.
My clerk went to this place, but they are not sitting. But their email is mentioned in the net. For this reason, I have served, Lordship. But their respondent
service, sir. That is
but Lordship, respondent do very well know the address of the food this private respondent. If the respondent give me information, I will serve. Because I do not know. I only got this copy. I do not know the unlawfully in connivance with the private respondent unlawfully transfer the land to another person by acquiring the land with one object and transfer to another person by the respondent authority.
But after receiving compensation,
till the
they
date,
have
Lordship,
come
they did not give any
challenging the
compensation.
acquisition proceedings, my lord.
Did not give
Section
any
30, they have, my lord, initially the award was dictated in the name of another person, my lord. Thereafter, they have Section 30 application before the civil court, my lord. Thereafter, they have received, as per the order of the landed civil court, but they have received the compensation amount, my lord. Thereafter, Section 18, they are not satisfied with the compensation money, they had preferred Section 18 before the, my lord, civil court. They have, my lord, amount enhanced. Thereafter, they have received the amount. Thereafter, they are coming, my lord, saying that the acquisition proceedings is bad. My lord.
Lordship, has
After
notice was-
receiving acquisition money, whether they can, my lord,
You have received the
challenge.
compensation?
Lordship, first notice was sent to the petitioner in the year 2007. Under compelling circumstances, petitioner received this meager amount, Lordship, because petitioner was
And
not.
you have challenged the amount under
Thereafter-
Section 18.
Thereafter, I have challenged before the.
Can you challenge the proceedings after that?
Lordship, thereafter, I challenged before the lower court and before the tribunal. Thereafter, tribunal passed order in the year 2022. Tribunal enhanced the amount, and thereafter, Lordship, the respondent authority directed the respondent authority to pay this amount. The respondent authority did not pay till the date. This order was passed in the year 2022, but till the date not was paid. Thereafter, Lordship, petitioner consulted with me in the year 2023, 8th of September, Lordship. When I searched the net, then I found the net copy, which is an status of the which is found from the net. Where petitioner first time came to learn that this land was transferred to another person, Lordship.
So what is your difficulty? You have received compensation.
No, Lordship,
They can give it to any person.
they did not give me proper compensation in spite of the order of the lower court.
You can ask for compensation, sir. It is acquired land.
But Lordship, the purpose for which land was acquired, the purpose was not complied. They acquired the land. Kindly see page number 13, Lordship. They acquired the land construction for pharmaceutical company of Infant India Limited. Thereafter, Lordship, when I got information in the year 2023, petitioner first time came to learn the land was transferred to another company.
Private person.
Private person, without following any procedure of law. Not only that, Lordship, this this notice only first issued to the by the respondent to the petitioner in the
Well, that is his case. You have transferred it to a private person.
But once the land is vested, my lord, it
You
is
have to
acquired.
utilize for the purpose for which it is vested.
Public purpose, my lord.
Is this public purpose?
But thereafter, but there,
Page 13.
after my lord acquisition, my lord, the land is in possession of the my lord government, my lord.
Maybe, but can you give it to some private person? You cannot.
But that is why my lord, private person. But that is not their lookout. They have received the my lord compensation money.
You have to utilize it for the purpose it is vested. The government cannot do anything and everything with the land.
But that is appears for my report, my lord.
The purpose was construction of pharmaceutical company.
Initially, that was my lord.
Yes. Then after that, you have given it to the private respondent.
thereafter transferred to another company, lordship, which is annexed, lordship, kindly see page number, which is annexed at the last page, lordship. Prabhuji Pure Food Private Limited.
That is the private respondent.
Private respondent, lordship.
You have come to know that in 2023.
Lordship, petitioner came to learn of this fact after getting this information and consulted with the advocate, lordship.
But after getting compensation, whether they can my lord, return back the land, my lord.
Can you utilize the land for
That I shall take
purpose?
instruction whether that has been my lord, utilized for private purpose or my lord, the
Yes, you
public.
have to.
That I have to, I shall take instruction.
Government cannot do business with the land
No, that
after
is-
acquiring it.
Yes.
Please take instructions, file a report.
Yes.
And in the meantime, please serve. Otherwise, I cannot take up the matter for hearing.
Lordship, not only that, they know very well the address of this. Kindly direct the give the
Can the
address
court
of
do
the
that?
I will serve.
Can the court do that?
Lordship, I do not know because the address of the I got from the net information, Lordship. Because only name has been mentioned in the land status report.
Please send it officially to this address. You have not sent, you have sent some person there. You have not sent it officially.
I got in email.
Please serve officially.
Just again I will sub.
Yes.
Lordship. Again I will sub. Lordship.
Serve it physically.
Lordship. Again I will sub. But my clerk went to this place. They are not sitting
Is that considered to be service?
But I have served through mail.
So,
I will again serve, Lordship. I will again serve, Lordship.
service through mail is
I will
not
again
very acceptable.
Lordship, not only that, may I tell Lordship, they resorted the procedure from very beginning without established proceeding of law.
You cannot challenge the procedure like that, sir. Your only point will be utilization for a different purpose.
And even they never raised this point before the my lord, civil court.
They
Twice
have
they have
come to know after that. They say they have come to know in 2023. The civil court order is in 2022.
Yes.
It is submitted on behalf of the petitioners that upon acquisition of the property of the petitioners, comma, the state has utilized the same for purpose other than which it was acquired.
My lord, state has my lord transferred the land in favor of my lord, pharmaceutical company for public purpose. The company has my lord transferred that my I shall file report, my lord.
Learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, since service upon the private respondent is not complete, comma, let the matter stand over till 1st February? 1st February? Next. Oh, no, under the heading motion. Let the matter appear under the heading group 1 motion on. Next. $507.
Yes, sir.
507.
507. Two 1906. Here, are these service? Oh, good. Hello.
My lord, the land petitioner is a patta holder.
Service.
Ipsita Banerjee, my lord, appearing on behalf of the my lord, petitioners, my lord, the patta holder, my lord, his name is already,
Response.
state already states, my lord.
Yes, anyone is appearing.
Ipsita Banerjee appearing on behalf.
She appeared on the earlier occasion.
No, my lord, this is the first time, my lord.
You have seen her name.
Notice, my lord, kindly I have sent the notice. Yesterday, my lord, I served the notice, the matter will appear.
This is the only Amitesh Banerjee book. Amitesh the book.
She has been allotted the group.
Ipsita Banerjee appear है ना? No.
I appearing on behalf of the state with
Yes.
Miss Ipsita Banerjee.
Well, kindly see my page 14, my lord. This is my record of rights. My lord, I am petitioner of the patta holder. My lord, then my lord, his land has acquired. My lord, my only prayer, my lord, that my residential building as well as trees may be considered at the time of compensation. My lord, I made a representation, page 16. My lord, that should be considered by the, my lord, the LA collector. Page 16, my lord, this is my representation.
The building and trees.
Building and trees.
Let this be considered.
My lord, may I file a report?
For a page time, details report.
আমি ল্যান্ড আমার বাড়ির আর এটা কনসিডার করার জন্য শুধু ল্যান্ডটা দিয়েছে অ্যাপ্লিকেশন দ্যাট উইল বি
Sir, application.
Yes.
Consider করা হয়নি?
কনসিডার করা হয়নি
My lord, it is, we have paper not today and keep it tomorrow. I'll just discuss it with my clients also.
There's a representation. Please come to page 15 of the report.
Yes, my lord.
The petitioners say you have granted compensation for the land and the pipelines, I believe.
residential
Not-
building
not
and
for the residential building and the
and
trees.
please
My lord, I remember, but my lord, may I hand over the report? And my lord, it will be clear. Excellent.
यादव 507 507 100 পিছিয়ে গেছে এগিয়ে গেছে
The report says that they have granted compensation, land and tree compensation.
and
My lord, there was no house damage during the.
no there's
No, but you say that you have granted compensation with
Yes,
regard
my
to
lord.
trees, solatium, crops, everything.
Yes, my lord.
And no residential house was damaged.
but then my lord, the details may be my lord supplied to the petitioners. Well, residential building
Have him,
right, residential building my lord damage.
Copy of this?
No, my lord, there is no.
Please take a copy.
My lord,
Go through this and come back. Yes, please go through the
Yes.
copy and conduct. Affidavit of service. Detailed report submitted on behalf of the respondents is taken on record. Paragraph, then, copy of the report is made over to learned counsel for the petitioners in court this day. Paragraph. Prayer of the petitioners, the matter is admitted. Paragraph, let the matter appear under the same heading on 6th February. My lord. 6th February.
6 February.
কি বললো?
6th February.
ছয় দুই। Next date.
My lord, the petitioners.
My lord, I am for the statement.
My lord, the petitioners, my lord, page 16. The petitioner is the owner of the page 16 is the owner of the property. My lord, the land has already acquired, but till today, my lord, not yet released the compensation. My lord, paying consideration of page 18. My lord, my representation and 25th August 2023. My lord, this is my representation. The land was acquired.
Yes.
Yes, my lord, I have not received any instruction, my lord. So the very next day.
Let the representation be considered. The petitioner is seeking payment of compensation, release of compensation. He says that his land has been acquired and no
Yes, my lord.
compensation has been paid. He has filed a representation. Page 18 of the petition. Yes.
Yes.
Service name. It is submitted on behalf of the petitioner that his land was acquired by the respondents his land, a portion of his land. A portion of his land was acquired. Land was acquired by the state respondents for the purpose of construction of pipelines, but no compensation has been paid to the petitioner for the same till date. Stop. The petitioner submitted a representation in this regard before the concerned authority on when did you file the representation?
On 15th August 2023.
25th August.
25th August, my lord.
On 25th August 2023, which is yet to be considered. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that who should consider the
LA collector.
Elector. Respondent number 3.
The third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petitioner is disposed of directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such. Within 1 month?
Yes, ma'am.
Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph. In the event the petitioner is found entitled to compensation, such compensation be disbursed in favor of the petitioner within 2 months thereafter. Disposed of which after 1 month and 2 months for payment.
Yes, ma'am.
Next. 509.
Milord, it is also a similar matter, Milord. The only thing, Milord, is that the verbal instructions I have received is that the entire land which they are saying has been acquired by the state, my lord, is not correct. They are saying, my lord, 19.6 have been acquired and 8.4 they have received compensation and balance is due. According to us, my lord, the only 8.4 was acquired and balance, my lord, was never acquired and therefore no compensation was made. However, my lord, if your lordship directs that we'll
No, no, my
consider-
lord, if my lord state my lord submit this, kali record and my lord dispose this.
So
Then my lord, I am entitled to what?
But
to
you said
take-
11.1.
No, yes, my lord, kindly see, my lord, 19.5 my lord total land acquired. As per
That is what is the dispute. According to the instruction I have received, my lord will keep it tomorrow. I'll have a written report. That will, my lord.
well, their statement is only acquired 8.4. But my lord, fact remains, my lord, they installed the pipeline my lord, through my lord, this
And there are
land.
several joint surveys
Well,
which
each-
were undertaken, where, my lord, these survey reports are also there, where from it appears that only 8.4 was acquired and that 11.1 was never acquired. However, my lord, there has to be something in writing before your lordship, which I don't have today. So, my lord, kindly give me some time, I'll put it on writing. Alternatively, my lord, if this representation can be considered.
Or else let the representation be considered.
Yes,
Yes,
yes.
the representation may be considered.
Representation may be considered.
Page
That, my lord,
16.
the allegations, my lord, may not be admitted. That's all.
The petitioner claims to be the patna holder in respect of the plot in question and submits that 19.5 decimals of his land was acquired by the respondents for constructing a pipeline for GAIL, GAIL capital, bracket India Limited, bracket closed, Limited. Stop. No compensation has no targeting. Compensation has been paid to the petitioner in respect of 8.4 decimals of land and the balance compensation is yet to be paid. The petitioner submitted a representation in this regard before the concerned authority on 25th August 2023, which is yet to be considered. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. The contention of the petitioner is denied and disputed by the state respondents. Stop. Learned counsel for the state respondents submits that the third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph. In the event the petitioner is found entitled to compensation, comma, such compensation be disbursed in favor of the petitioner within 2 months thereafter. Decision is up to the authority.
Yes, if it is entitled to compensation, if
Then
at all
another
land
2
was
months.
acquired, then of course.
Disposed of it. Next.
But I appear on behalf of the petitioner.
Not today, because I could not bring the file tomorrow.
Not today.
My lord, only one thing, my learned friend is filing a report. I should file the exception to that. Lordships can take up the matter next week.
Yes, madam.
Next week,
I have already
next week.
handed over the copy of the report to my learned.
But they have
It's not on record as yet.
not on record. He has served me. That's why my lordship can take up the matter next week. But I shall file the exception.
Learned counsel for the petitioner seeks to use an exception to the report in the form of affidavit, comma, copy of which has been served upon him. Paragraph. Let the matter appear under the same heading on 30th January. No,
30th.
under the heading motion. 30th.
30th. As your lordship.
Have an advance copy.
As yours. I shall.
Next.
Sir, এদিকে যান আপনি।
My lord, this is with regard to, my lord, removal of unauthorized structure on the national highway, my lord. On last occasion,
I am the private project. Private is not bad party. Not
Excellent.
required.
Not, we are challenged that order before that.
My lord,
Before the
my lord, kindly see there, this is the order of the project director, my lord. Project director's order, my lord. My lord, he challenged up to division bench. My lord, interim order, my lord, refused. He challenged before the civil court, refused. My lord, he has no locus standi, my lord. What he is saying that a person who is, my lord, a person who is trespassing on the national highway. Yes, national highway, my project, my lord, kindly have a, my lord, page 35. My lord, kindly see order of the project director. And already, my lord, in terms of the order of the project director, my lord, demolition started, my lord. Demolition process started. They admitted before. My lord, admitted.
Hey, I'm state.
My lord, kindly see your lordship's last order.
And without hearing the national highway, I will not pass any order. That is that, my lord.
My lord, a wrongdoer can't say, my lord. He is a wrongdoer.
Demolition has been started, my lord. My lord, my humble submission, lordship, kindly lordship provide proper police support by so
Well, kindly direct that.
I have later, my lord, on 1st January 2024, have been sent a letter.
It will be pending forever. Has হয়েছে তো।
Have been sent before, my lord, before the division bench, my lord, that is a different, my lord, the different matter.
No, my lord.
Matter for which, my lord, this is the one Allah Rakha matter, my lord, that is stand number, my lord, mat number 2562 of 2023.
কালকে দেখালে, হ্যাঁ?
My lord, they have some mark, lordship, lordship.
হ্যাঁ, এটা কার সঙ্গে আছে এটা? আল্লাহ রাখা।
Allah Rakha is not a,
The father of Zakir.
The similar matter, my lord. That is the order.
maybe similar, sir. It is not the, I mean, you have not preferred an appeal.
I have prepared appeal.
এই এখানে প্রাইভেট এর সঙ্গে এই তো
40, my lord.
আল্লাহ
Before the
ও আচ্ছা আচ্ছা, এটা তো না।
you have prepared appeal. Appeal is pending. They are not appearing. National highway.
Don't have to, my lord, I have not received the copy, my lord, on that date.
No.
Why make
My lord,
submission?
ex party they move, my lord, no interim order. ওরা কোনো, there is no relation, no nexus.
কোনো প্রসেস হাইকোর্ট অর্ডার উপরে ডিস্ট্রিক্ট যায় হাইকোর্ট অর্ডার উপর ডিস্ট্রিক্ট যায় লাস্ট ম্যাটার
হ্যাঁ।
You intend to appear for whom in this matter?
private respondents, my lord. My lord, I am being disposed.
I'm asking for the names.
ও জানেই না।
চালাও নাজির শাহ আল্লাহ রাখা শাহ
His status has already been decided by project director by giving opportunity of hearing.
আল্লাহ রাখা শাহ নাজির শাহ, my lord.
Complaints.
The same land, my lord. And on my land, my lord, I am being evicted without taking any party here. Appeal is pending before the appeal court.
My lord, this is on the national highway, my lord. Structure is on the national highway. Project director will not pass order to asking for removal of structure on a private land. My lord, kindly see, my lord, page 35 of the writ application. By implementing some stranger, my lord, he can't, my lord, save his, my lord, encroachment on the national highway.
I think no further order is required to be passed at all in the writ petition. Because the authority says.
Yes. Your lordship kindly provide police.
Many other things, lordship.
Police also, that is also stated in the division bench order. That police assistance has been asked for.
My lord, I need
More assistance.
On 1st January 2024, lordship, we wrote a letter to the lordship, the district magistrate, the superintendent of police, and the sub-divisional officer Kharagpur,
You can ask them for more assistance.
Well, if you lordship can
Because,
respond,
let
please,
me tell you, if I have to pass an order, I have to give an opportunity to file a CAN application. He has to appear in this matter, I have to take a report. Procedure. If I do not pass any order here at all, there is no question of adding any.
I tell you, Lordship, my lord, only 1 second, my lord, because it was this report I have, my lord, is of the earlier position till October.
You are appearing for?
On the state respondents. Well, till October, with the annexes, the report stated that, my lord, they had approached us, and then we had provided, we agreed to provide, then it was postponed at their instance. Now, my lord, since my learned friend told me that it on the 1st of January, I had taken, my lord, verbal instructions over phone. I was told that as it has fallen before, submitted before lordship, part demolition has taken place. The next date, my lord, I am being told over the phone that by the police authorities that the highway authorities will approach them today or by tomorrow. We shall immediately render the assistance. So it can be done. No difficulty.
To that effect, my lord, kindly pass order because I
How
am
can
the
I?
was prejudiced person, my lord.
Request you to withdraw the report.
That's right.
The other option is I have to allow learned counsel
Correct.
to come back with a CAN application for addition of party, and the matter will be pending.
My lord, we have challenged this. The
You have
order
not challenged anything. You have asked
that,
for implementation.
though project director found that there was encroachment on the
Prayer is for implementation.
yes, exactly.
You are not challenging anything.
No.
So even without your prayer, the order is being implemented. So what is the, why do you want to keep this pending?
In view of the subsequent developments, we will know now.
But since, my lord, police, my lord, started demolition, my lord, since National Highway Authority also, my lord, praying for more assistance, my lord, more force, my lord, that
I'm not able to explain well. Let him come back with an application for addition of party. Let it continue.
Then my lord recorded my submissions, lordship, in my because
This is the copy
if
of
that
the
be so, my lord recorded my submissions.
Not
এটা করলে জীবনে হবে
Recorded my submissions,
ও
lordship.
করলে করো কেন করো ওরা করতে চাইছে ওরা করতে চাইছে তা আমরা কি তুলে নেবো
That will delay your implementation, nothing else. There will be no implementation unless the matter is heard and disposed of.
then, my lord, I'm agreeing to withdraw the matter, my lord, in view of the changed circumstance.
The subsequent
lord.
developments.
My lord.
My lord, this.
Let him not proceed with the matter at all. Let you appear before the division bench and make out your case there.
My lord, this instruction of October will be kept on record. I'll keep.
There is January now.
All right, my lord, I am withdrawing, my lord.
It is submitted on behalf of the respondents that in compliance with the order passed by the project director
Page 35.
on 24th March 2023, comma, the unauthorized occupations are being demolished and the authority has sought police assistance for implementation of the order. Stop. It is further submitted that a portion of the unauthorized occupation has already been demolished. Paragraph in view of the subsequent change in the circumstances of the matter, comma, the writ petitioner seeks to withdraw the writ petition. Paragraph in view of the above, the writ petition being WPS such and such is dismissed as withdrawn. Paragraph, there shall however be no order as to costs, urgency defined by secretary.
My lord, require lordship to record this order of the division bench, lordship.
Different forum, different, my lord. Different. And I'm not telling anything on merits.
My lord, next matter. My lord, earlier.
We are not asking for taking up the matter tomorrow, lordship. Let it retain its position tomorrow.
Well, it is going down every day. That's why it could not be collected.
Because every day mentioned matter, they are bringing at the top, and the matter which are existing, they are going down.
The list is very slippery, sir. Can't help.
My lord, your lordship on the previous occasion, my lord, were pleased to pass the order on the next day, my lord. My lord, only passing the order that the secretary
Joint secretary will decide the issue.
Consider and decide the matter, my lord. Only that order.
Let us see.
My lord, let it be written or top.
My lord,
This is the first matter.
as per my lord, every day, my lord, only that is disposal considered by the.
দিদিটা দিদিকে রাখো।
দিদিকে ডাকছি।
512 এটা একটু উপরের দিকে তুলে দিন।
At 528, same point. Same state advocate is 28, same advocate, Mr. Shah,
Let us-
28.
let us-
28 টা কি ম্যাচ?
And Samsudin.
শামসুদ্দিন আমিনী।
হবে।
Today there is 3:30, tomorrow 3:30. Now, this is a matter which my learned junior had mentioned, Lordship has allowed it, of my lord the urgent list of Justice Shampa Sarkar. This is an order, my lord, 227 against my lord an order of the NCLT. Now, my lordship has fixed it. It is 591. So either, my lord, if today at 3 o'clock or tomorrow at 3 o'clock, because we are confirmed tomorrow there is a 3:30, my lord. ওটা ছেড়ে দিন আগে।
591.
Yes, Monday the matter is fixed in NCLT. That is why Lordship had allowed it. But my lord, it is impossible because it won't be taken up either today or tomorrow, my lord.
Very well, tomorrow 3 o'clock.
Tomorrow 3 o'clock. Very well.
দিদি ওটা একটা নোট রাখুন তো, কালকে 3 o'clock. 591, কালকে 3 o'clock. 591.
এটা কি দেবো ধরতা? কি ওটা? ঠিক আছে। Tomorrow at 3 p.m. Malu. Grateful. Deep love.
Yes, call the reasons.
538, Group 7 content application 538.
I'm for to petition. এদিকে চলে এসো অমল এদিকে এসো অপোজ করিনি আপনার সঙ্গে তো আমরা সবাই
Yes.
I have filed my affidavit by taking exception to complaints compliance. Only your lordship kindly consider that.
My lord, in one matter, Mr. Debroy, in other matter, similar matter.
There are three matters, two matters, myself and Mr. Same also.
Because issue is same, my lord. Non-compliance of the order.
Contempt arises out of the non-compliance of the order of your lordship date 20th December 2022.
Yes.
আমি তো সব দিয়েছি কোনটা করে আপনাকে বলেছি তোমাকে খাটতে হবে
Permit has not been granted as yet.
They have no time, my lord. They fixed time for hearing. They were absent successively. I could not appear before them. Your lordship kindly see the affidavit complaint. I have taken exception. If your lordship kindly, I submitted on 11th of December, my lord. If your lordship kindly have a grounds, my lord.
The exception?
Yes, my lord, exception.
Yes.
Kindly see, my lord. Details I have dealt with, my lord. Kindly come to page 2, paragraph 3.
ওই নোটিফিকেশন যেটা নোটিফিকেশনটা অ্যানেক্সচার করেছো এই নোটিফিকেশনের জন্য দিতে পারবো না
আমি চিসন্দ্রমূল্যে করছি ঠিক আছে paragraph 3 with reference to the statement made in paragraph 5 and 6 of the said affidavit I did not dispute the same 7 hexawatt matters record.
You are right.
I further say that after receipt of the hearing notice on 18th of September 2023 I had attended the hearing scheduled to be held before the respondent 2 on 22nd of September 2023 at 3 p.m. After attending the place of hearing, I waited for long. When there was none present at the said hearing, in terms of the hearing notice dated 18th of September 2023. After long waiting, I had left the place and submitted an application, and the same was received by the official content opposition party on 22nd of September 2023 at 3:45 p.m. It was endorsed in the said application that neither the district magistrate, South 24 Organas, nor the member of the board was present at the meeting. I also say the allegation made in the paragraph 6 of the affidavit is a false and fabricated story set up by contempt opposition party for which he should be proceeded under the provisions of the Contempt of Courts Act 1971 for justifying the act of compliance of the order of the Honorable Court dated 20th December 2022. Kindly see the
reading your exception affirmed on 1st September. Oh, no, 1st December. Yes.
No, 1st December. And if your lordship kindly come, their affidavit.
Yes.
Paragraph 5 and 6 of the affidavit of compliance.
Yes.
Paragraph 5, that in compliance with the order, with the terms of the solemn order dated 20th December 2022 in WPA number 27201 of 2022 and the solemn order dated 14/6/2023 in CPN number 453 of 2023 of the Honorable High Court at Calcutta, and also as per advice of Mr. Devrai Malala addition, Government High Court, Calcutta, being the chairman of the Regional Transport Authority and District Magistrate South Sudan, issued a notice of hearing to the writ petition and all the interested parties for appearing on 18th of July 2023 at 3:10 p.m. That on the scheduled date of hearing 18/7/2023, the matter was heard in length in the presence of Sri Sumit Gupta, Chairman, Regional Transport Authority, District Magistrate Collector, South 24 and Sri Munturam Pakhira, Member of the Regional Transport Authority, South 24 and Sri Omyo Kumar Kundu, Secretary of the Regional Transport Authority, South 24. After hearing the submission of the petition case record, the board took the following resolution. Let them produce the proceeding they have taken. This must be, there is a camera, my lord. Let them produce that camera report, my lord.
ক্যামেরা থাকতেই হবে মোটর ভেহিকল বই বই আছে বলা আছে
It has been circulated to everywhere.
না না মোটর ভেহিকল বই বলা আছে যে
There was no hearing, no present. Categorically stated, my lord.
চিঠি না না
Hearing.
ক্যামেরাটা কোথায় বলা আছে আইনে আমি তো এটা পাচ্ছি না বইটা বার করো
Desperate rogate, desperate suit. এটা তো জানো তো?
না না
তাহলে জানো না, তাহলে চুপ করে বসে থাকো। ওটা কমপ্লাই করবে না তুমি, আর তুই বলবে এসে বলতে হবে
রেগে যাচ্ছে না
না না দেখো 18/7/2023 they have alleged that the resolution was taken. I was not, and also stated that I was not present. Then
করেছেন
then hearing notice 18th of September, your lordship kindly see. I think they submit again 18th of September.
Are you aggrieved by the ground of rejection?
No, I am aggrieved because non-consideration of my application. But your lordship kindly come to page 9 of the affidavit. They again directed me to appear before them. If they have concluded the hearing by taking resolution on 18th of July 2023, then question of giving notice to me for hearing before them on 22nd of September 2023 is an absurd. On page 9 of my affidavit of compliance, take exception to the affidavit of compliance matter.
It was decided on 5th October 2023.
And I have shown my your lordship kindly see. In the affidavit of compliance, they have stated 18th of July.
Page 7, 5th October. The resolution was taken on 5th October.
Notice was dated 18th of July. Date of hearing, your lordship kindly paragraph 4, page 4, paragraph 6. Affidavit of compliance. That on the scheduled date of hearing dated on 18th of July 2023, the matter was heard in length in presence of Sumit Gupta, Chairman, Regional Transport Authority, District Magistrate, and Collector, South 24 Hours. Number 2, Sri Mantuna Bakira, Member of the Regional Transport Authority, South 24 Hours, and Sri Omiyo Kumar Kundu, Secretary of Regional South 24 Hours. After consent submission, the petitioner, after consent submission, the petitioner, I did not appear, and case record, the board took the following resolution. They say on affidavit that we took a resolution by 18th July.
This resolution is in February, 27th February, where 18th July? Where do you find July?
I am placing their affidavit of compliance.
Yes.
Affidavit of compliance, paragraph 6.
10th October.
Paragraph 6, my lord.
Found on 10th October.
This is, my lord, I received on 24th of August 2023.
The affidavit of compliance.
Compliance. First affidavit of compliance.
No, I'm on the second compliance report.
Second compliance.
There is another affidavit of compliance after that.
First affidavit of compliance, they said they took a resolution on 18th of July, and second, my lord, your lordship can see. Huh?
ওটার পরে আবার হয়েছে
হ্যাঁ
স্যাটিসফাই করার জন্য সব রকম ব্যবস্থা রয়েছে
Kindly come to second affidavit of compliance, paragraph 5.
Yes.
That in compliance with the terms of the solemn order dated 20th December 2022 in WPA 27201 of 2022 and solemn order dated 12th of September 2023, CPA number 453 of 2023 of the Honorable High Court Calcutta, being chairman of the Regional District Magistrate of South 20 issued a notice of hearing on 18th of September 2023 to the petition and all the interested parties for appearing on 22nd September 2023 at 3 p.m. Reply, your lordship, kindly see. This reply, your lordship, kindly see my exception.
Yes.
Paragraph 3, page 2, my lord.
Yes, yes.
With reference to statement made in paragraph 5 and 6 of this affidavit, I deny and dispute the same. 7 except what matters record. I further say, after receipt of the hearing notice dated 18th of September 2023, I had attended the hearing scheduled to be held before the respondent 2 on 22nd September 2023 at 3 p.m. After attending the place of hearing, I waited for long when there was none present at the said hearing in terms of the hearing notice dated 18th of September 2023. After long waiting, I had left the place and I submitted an application, and the same was received by the office of the concerned opposite party on 22nd September 2023 at 3:45 p.m. It was endorsed in the said application. Neither the district magistrate South 24 Hours nor the member of the board was present at the meeting. I also say the allegation made in the paragraph 6 of the said affidavit is a false and fabricated story set up by contempt opposite party, for which he should be proceeded under the contempt of court order 1971 for justifying the act of compliance of the order of the Honorable Court dated 20th December 2022. Kindly see my letter. If your lordship kindly come. Page 8. To the Chairman, Regional Transport Authority, District Magistrate, South 21. আপনার পাঠানো হিয়ারিং লেটার গত 18 সেপ্টেম্বর 2022 হাতে পেয়েছি। যথাসময়ে লেটার পাওয়ার পর আপনাকে ধন্যবাদ জানাচ্ছি। ইতিপূর্বেও আমি হিয়ারিং লেটার তাই 18/2/23 হাতে পেয়ে আপনার দপ্তরে গিয়ে দেখা করে যথাস্থানে আপনার অফিসের সমস্ত মূল্যবান কাগজপত্র জমা করে রিসিভ করিয়ে নিয়েছি। আমি সামান্য একজন গাড়ি চালক, আমার অর্থনৈতিক অবস্থা মোটেই ভালো না, ডিউটি না করলে সংসার চলে না, তাই বাধ্য হয়ে পরিবারটি মুখে তাকিয়ে আবারও আপনার চিঠি পেয়ে আপনার দপ্তর হাজিরা দিয়ে মূল্যবান কাগজপত্রের জজকে জমা দিলাম। চিঠি মেমো নাম্বার সাত। This is received on 22nd September, the date of hearing at 3:45 PM. Therefore, madam, there was no meeting. And paragraph 6, madam, kindly see. Paragraph 6 of the affidavit complex, they say that on the scheduled date of hearing on 22nd September 2023, the petitioner, the chairman of the Regional Transport Authority, the secretary of the Regional Transport Authority appeared. The board member of the Regional Transport Authority is also a member of the West Bengal State Legislative Assembly. At the scheduled time of hearing, he was occupied in proceedings of the House, and he communicated to slightly delay the scheduled hearing, which was duly communicated to the petitioner, which came at 3 PM, and he verbally consented to the rescheduled date of rescheduled time of hearing at 4 PM. The undersigned being the chairman, being the district magistrate chairman RTA, District 24 Banaras, presided over this meeting, hearing. However, when the RTA board was about to hear the matter at 4 PM, the petitioner was not there. The petitioner submitted over the telephone, that due to unavoidable circumstances, he is not able to attend the hearing. He also informed the RTA board that he had submitted written representation dated 22nd September 2023 in connection with today's hearing. In the absence of the petitioner, board of the Regional Transport Authority Satpura had taken resolution on the same day, whereby the RTA board adjourned the hearing of the matter on that day and fixed the next date of hearing on 22nd September 2023 at 4 PM.
Yes.
Madam, I had not been informed. I deposited my letter that I left the place.
And they say that after that the hearing was
They are justifying the delay on that by that fashion. They are covering the delay by that fashion. And 7, 8, 9, my lord, your lordship can see.
But have you seen the ground of rejection? You were not heard by the authority. That is your.
I have not, your lordship order I have not complied with. That is my whole trouble.
Let us hear the authority.
Let the council, let the at all consider. They will be taking all these grounds before the court.
They say that they have considered a resolution has
Not,
been taken.
I have not been heard, not considered at all.
Yes. The first matter, please.
Just since the three matters are same. So, may I please, lordship? The first of all, lordship, whole thing is that this is a contempt application. This is not an original writ petition. Now, there was an order passed by your lordship while disposing of the writ petition. Now, the contempt application arising out of that the said order has not been complied. Now, it is, my lord, naturally, my lord, the either contempt application, my lord, at the instance of somebody by filing a petition or suo motu. Now, here it's a case where by filing an application, the contempt proceeding has been initiated. Now, the whole thing is that my lord has to look into the facts as well as, my lord, whatever the points of law involved in contempt jurisdiction or in contempt of court proceeding, that whether it's a case of now at this stage after, my lord, the filing of the second compliance report, whether still, my lord, this proceeding can be, my lord, allowed to go on, or, my lord, it can be dropped. Because whatever his prayer in the main writ petition, we are not at all concerned. His application was for grant of permit. His application has been rejected eventually because of certain, my lord, the facts, and, my lord, there are certain bar in view of notification.
The petitioner get an opportunity of hearing before the.
My lord. Now, this is my lord, the question is that opportunity of hearing, whether the opportunity of hearing was given to him, whether hearing was given to him. These two things, my lord, two expressions are different. always expression is that whether opportunity of hearing was given to him. My lord, I bow down to your lordship. But the expression can never be that whether hearing was at all given to him or not. Here is the question whether lordship kindly consider, after going through several documents we have annexed to the, my lord, the second, my lord, the compliance report by way of affidavit, that whether that opportunity of hearing was given him or not. If somebody choose to left out the proceeding, if somebody choose that no, he would not appear any further. Yes, I appeared once. You given a time 3 p.m. I waited there for half an hour or more than half an hour, but not more than 40 minutes, because it appears from his letter itself that at 3:45 p.m. he left the place. Nobody was there for the purpose of, my lord, that consideration process. The authorities, none of the present, it is according to him. So he left the place. Very good. My lord, may I tell one thing, lordship, that there are several reasons for which there are several reasons which may arise. Several reasons may arise that may prompt the authority or may prompt the, my lord, the person concerned who is entrusted to take hearing, may not take the hearing, may be absent. Lordship, kindly consider. It may happen everywhere in the judicial proceeding also. Lordship, kindly consider. A time is given, but at that time, my lord, matter is not taken up. That does not mean that the litigant would left out the place and say, I would not appear again any further on the next day. Here what happened, lordship, kindly, my lord, come to my affidavit of compliance. That what is actual motto? Actual motto, may I tell before lordship, is there, I'm a bit sorry to say, that eventually I have to surrender. When there is no scope to grant permit, but on the threat of contempt, I have to surrender. I have to yield. The lordship, kindly, my lord, come to affidavit of compliance. A few paragraphs, lordship, kindly come.
You have turned down the prayer of the, so there is no question of the force.
But whether that opportunity of hearing at all given or not, lordship, kindly, I restrict myself to that expression, opportunity of hearing. Lordship, kindly, paragraph number 5. Only a few paragraphs, lordship, because contempt is a, my lord, it's a very serious nature, contempt. Lordship, kindly consider. Now, that paragraph number 5.
Yes.
That in compliance with the terms of the solemn order dated 20th December 2022, there is the, my lord, the main order in 2022, and lordship, kindly consider, and solemn order dated 12th of September 2023 in CPAN 454 of 2023 of the Honorable High Court, Calcutta. The second order was, my lord, my lord was kind enough to pass this order. When, my lord, it fell from your lordship that the first compliance report is not sufficient. Then, my lord, it was our joint prayer that very good, my lord, the liberty is given to us, another scope, so that the order can be complied with. So, my lord's order, in terms of my lord's order of 12th September 2023, the chairman of the Regional Transport Authority and District Magistrate South 24 Pargona issued a notice of hearing on 18th September to the writ petitioner and all the interested parties for appearing on 22nd September at 3 p.m. Now, what happened on that? On the scheduled date, the next paragraph, on the scheduled date of hearing on 22nd September, the writ petitioner, chairman, Regional Transport Authority, and the secretary of Regional Transport Authority appeared. The board member of the Regional Transport Authority is also a member of the West Bengal Legislative Assembly. May I pause here for a moment, lordship. My lord, the board, RTA board constitutes, my lord, the district magistrate by ex officio, and my lord, there should be a board member. Now, my lord, board member is an outsider. He is a, my lord, MLA. At the scheduled time of hearing, he was occupied in proceedings. He could not come in time. Proceedings of the House, and he communicated to slightly delay the scheduled hearing which was duly communicated to the writ petitioner when he came at 3 p.m. This is on oath. Somebody has said this on oath that 3 p.m. the petitioner was intimated the same, that the board member would come very soon, so please wait. And he verbally consented to the rescheduled time of hearing at 4 p.m. This has not been denied. In his affidavit, this particular averment has not been denied. That no, it was not communicated. This is a concocted story, has not been said. The undersigned, being the district magistrate and chairman, RTA District South 24 Pargana, presided over the said meeting. However, when the RTA board was about to hear the matter at 4 p.m., petitioner was not there. The writ petitioner submitted over the phone that due to unavoidable circumstances, he is not able to attend the hearing. He also informed the RTA board that he had submitted his written representation dated 22nd September 2023, that is on the very same day, in connection with today's hearing. In the absence of the, now what was, my lord, what they have taken a call in this, that in the absence of writ petitioner, the board regional transport authority had taken a resolution on the same day, whereby the RTA board adjourned the hearing of the matter on that day, fixed the next date of hearing on 26th of September at 4 p.m. It is not a fact, it was not a case that despite being the fact that in his absence, next the board member appeared and we took the resolution. No, we did not proceed in the matter any further. Then Lordship kindly, 7 accept that the adjourn. Next 7, that the chairman of the Regional Transport Authority and District Magistrate South 24 Pargana, being the contemner hearing, again issued a notice of hearing to the writ petitioner and all the interested parties for appearing on 26 September at 4 p.m. The issued notice was sent through Narendrapur police station. The writ petitioner refused to accept the notice. According to the notice copy was fixed at conspicuous place of his house by Narendrapur PS, and he was again informed over telephone to appear on 26 September 23 at 4 p.m. on the day of hearing. The board member of the Regional Transport Authority and the secretary of the Regional Transport Authority appeared, signed the attendance sheet. Writ petitioner, for one person, my lord, the authorities, they used to come on all the next day. The writ petitioner was absent on call in spite of an effective service of notice. The undersigned, being the district magistrate and chairman RTA District South 24 Pargana, presided over the said meeting. In the absence of the writ petitioner, the board of the Regional Transport Authority South 24 Pargana had taken a resolution on the same day, whereby the RTA board again adjourned the hearing on the matter on the day and fixed the next date on 29. It cannot be a case that opportunity of hearing was not given. Then 8, that the chairman of the Regional Transport Authority and the District Magistrate South 24 Pargana, being the contemner hearing, again issued a notice of hearing to the writ petitioner and all the interested parties for appearing on 29 September at 5 p.m.
Can you show me service of this notice?
Yes. Nala kindly, my lord, let us, my lord, let me finish, my lord, another, my lord, one paragraph. Issued notice was sent again through Narendrapur police station and via speed post in both way. The writ petitioner refused to accept the notice. Accordingly, the notice copy was fixed at conspicuous place of his house. And they were again informed over telephone to appear on 29 September 23 at 5 p.m. One copy of the notice was sent to the petitioner's advocate, but he refused to accept the same. Malad advocate who used to represent the contemner here, the petitioner here, he also refused to accept. I do not know what is the actual motive. On the day of the hearing, the board member of the Regional Transport Authority and the secretary of the Regional Transport Authority appeared, signed the attendance sheet. The writ petitioner was absent. The 3rd consecutive day, on call, in spite of an effective service of notice. Undersigned, being the district magistrate and chairman RTA, presided over the said meeting. In absence of the writ petitioner, the board of the Regional Transport Authority South 24 Pargana had again taken a resolution on the same day, whereby the RTA board again adjourned the hearing of the matter on that day and fixed the next date on 5th October. 3rd adjournment, opportunity of hearing. He said that no opportunity of hearing. I am on that issue only, whether the opportunity of hearing was given or not. Then Lordship kindly 9, very serious matter, that the chairman of the Regional Transport Authority and the district magistrate South 24 Pargana, being the contemner hearing, again issued a notice of hearing to the writ petitioner and all the interested parties for appearing on 5th October at 4 p.m. with a specific direction that this matter would be decided ex parte. In case of the absence of the writ petitioner, the issued notice was sent to Narendrapur PS. The writ petitioner refused to accept the notice and did not allow the police party of Narendra PS to attach the notice at any conspicuous place of his house. The notice was also served through speed post to the petitioner. He was again informed over telephone to appear on 5th October at 5 p.m. One copy of the notice was sent to the petitioner's advocate. This specific abatement has not been denied. One copy of the notice was sent to the petitioner's advocate, but he refused to accept the same. The writ petitioner was again absent on call in spite of an effective service of notice. Thereafter, in the absence of the writ petitioner, the matter was heard and considered in length in the presence of, my lord, the board member and the chairman. And the resolution adopted, that is the, my lord, the resolution, which is, my lord, quoted here, and the, my lord, the annexed here. Now, all those, my lord, the notices and the attempt of service are all annexed to here. But where is the, my lord, the denial that no, these are not, these are not. He only denied that no opportunity of error is given. And lordship kindly come to one later. Yes, in his, my lord, the exception to, my lord, kindly come to that which averment is correct. Now, lordship kindly come to, my lord, page 8 of his exception. Page 8 of his exception. Affidavit affirmed on 1st December 2023.
Yes.
Have you lordship got it, my lord?
Yes.
Now, my lord, kindly come to, my lord, page 8.
Yes.
My lord, kindly, may I read out, my lord? Address to the chairman, Regional Transport Authority, dated. What is this? My 22nd September 2023. It carries the date, 22nd September.
Yes.
On the very date, when the first, he said that he was present there. আমার আপনার পাঠানো হিয়ারিং লেটারটি গত 18/9/23 তারিখে হাতে পেয়েছি। যথাসময়ে লেটার পাওয়ার জন্য আপনাকে ধন্যবাদ জানাচ্ছি। ইতিপূর্বে আমি হিয়ারিং লেটার 18/7/23 হাতে পেয়ে আপনার দপ্তরে গিয়ে দেখা করে যথাস্থানে আপনার অফিসে সমস্ত মূল্যবান কাগজপত্র জমা করে রিসিভ করিয়ে নিয়েছি। That means my presence is not necessary. Whatever documents I rely upon in support of my candidature and, my lord, in support of my application, I have already submitted with you. Then, আমি সামান্য একজন গাড়ি চালক। আমার অর্থনৈতিক অবস্থা মোটেই ভালো নয়। ডিউটি না করলে সংসার চলে না। তাই বাধ্য হয়ে পরিবার মুখে থাকি, আবার আপনার চিঠি পেয়ে আপনার দপ্তরে হাজির হয়ে মূল্যবান কাগজপত্র জমা করলাম। না, my lord, what does it mean? What is intention? What, my lord, tells this, my lord, the letter? That my presence is not further necessary. You asked me to appear before you for the purpose of hearing. I presented myself, but now I have already submitted all my papers in support of my, I think, application. You look it, you consider it. And another thing is this, lordship kindly, আমি একজন গাড়ি চালক। Now, my lord, kindly see the, my lord, the affidavit. This is an affidavit. Lordship, the, my lord, the second page of this document, second page.
Say that I need not be heard.
Second page of the document.
Yes.
Because false averment should not be allowed, specifically in a contempt of court proceeding. Lordship, kindly, second page of this document. My lord, I, Akbar Mistri, son of such and such, about aged about 41 years, by faith Hindu, by occupation unemployed. In his letter, he said, I am a gadi chalok, a driver, whatever be the page 2, because this, my lord, the format, this is, my lord, on affidavit is, my lord, of 1st December, my lord, the this is the, my lord, the exception which I read out just, my lord.
Yes.
The exception.
Ali Molla, not Akbar.
No, sorry. Oh, acha, dao, tomarta dao. Tomar exception ta dao.
You are on the next matter.
Yeah, yes, yes. Say, tomarta dao, exception ta dao. Eta the affidavit of compliance. Ami chaichi exception.
Yes, here he says unemployed.
Yes, yes, unemployed. And I am sure that the letter annexed to this affidavit also, the same language. আমি একজন গাড়ি চালক। And in the contempt application also, affidavit affirm, denoting that unemployed. So, my lord, kindly consider one thing. A person whose, my lord, affidavit format is also incorrect. And another thing is this, my lord, a person who repeatedly asks to present, how can I, my lord, I can give him what I am on. We always want to comply with the my lord's order, always. One day, one instance might have happened that yes, one of the member of the board member, he could not attend the hearing right time or in due time. Let us inform him. But consequence is that on all several locations, my lord, for 3 times, notices sent to him, Esho Baba, Esho Baba, Esho Baba.
Where is the
Because
third
also kindly
service?
consider one thing.
Where is the service of the subsequent
Service, yes.
notice? 18th September notice was served. And he has
Service,
replied to
yes.
that notice.
Yes, yes. Affidavit of compliance itself speaks about this. My lord, kindly come. The annexure. এইটিন সেপ্টেম্বরটা তো নয়, 22nd তো ছিল। My lord, the annexure R4 page 18, তোমারটা দাও না গো, তোমারটা দাও না আমাকে। না না, তোমারটা দাও। একই পেজ কি? কমপ্লায়েন্স দাও না, তোমার অ্যাফিডেভিট অফ কমপ্লায়েন্সটা দাও না। জিসান আলী, yes.
Page 47.
আমি আসছি। কি করছো? আছে আছে, সবাই একই আছে তো। মানে কাইন্ডলি কাম টু পেজ ফার্স্ট, মানে পেজ 38, and then my lord, all subsequent pages I would draw your lordship's attention one after another. My lord, page 38 is the letter of intimation about the next date of hearing, and that carries date 22nd of September. Now, both the second copy is the same. Now, my lord, kindly come to my lord page 40. Page 40 is the report of the, my lord, the inspector in charge of the local police station, addressed to the chairman, Regional Transport Authority, that this is kindly to apprise you that on receipt of the notice under reference, sub-inspector, such and such person was entrusted to cause service of notice, then kindly come to after 3-4 line, but all of them refused to accept the notice. Accordingly, notice copy were fixed at the conspicuous place of their respective house, and they were again informed verbally to appear on 26th of September in person along with all original documents. And this is the, my lord, a photograph annexed to this.
This is only the house.
Yes. Then, my lord, the again notice of hearing that is dated 26th of September 2023. And my lord, it was the postal service. Now, my lord, the photocopy of the envelope containing the, my lord, the address of the petitioner, it appears. Now, my lord knows that, may I just.
Page 44.
Page 44. Now, my lord knows very well, my lord, much more than me, that under Jail Clauses Act, in a postal service, if the address is correct, then tendering after a certain period, that would be assumed as correct service.
Yes, but what prevents you from filing the track report?
Why?
What prevents you from filing the track report?
Track record. Yes, track record. দেওয়া উচিত ছিল তোমার।
If there is a denial of service,
yes,
that is important, the track report. If you can show that the petitioner was served,
my lord,
then the petitioner has no case.
ট্রাক রেকর্ড এখন আর পাবে না বোধহয় এতদিন পরে আর। 9 তো না 26 নয় না 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 কিছুদিন পর পাওয়া যায়, ডিলিট হয়ে যায়। Then, my lord, kindly come to page 45. ট্রাক রেকর্ডটা থাকলে সুবিধা হতো। page 45. Again, my lord, it is a report of the police that yes, police went there for the purpose of serving, but they did not allow the police party to add, neither they receive nor they allow the police party. And here also, my lord, it appears that by post, all these notices were, my lord, tendered by post, page 46. একটা ট্রাক রেকর্ড গুলো দাওনি কেন?
He has got no track report.
Now, my lord, may I come just for that purpose, my lord, once, my lord, only a few minutes, lordship, kindly bear with me. ওর এটা কোথায়? ওর যে এক্সেপশনটা তোমারটা দাও।
Mr. Sen.
Just a minute.
Have any objection to rehear the matter upon hearing the?
I have no objection, but it will not, that will not, my lord, draw the cartoon. Lordship, the matter should be end. My lord, just ওর ইয়েটা দাও না, ওর এক্সেপশনটা দাও না, তোমারটা থেকে আমারটা আছে। Yes. আকবর না, আকবর নয়, তোমারটা জিশান আলী exception to. Well, last, my lord, let me go through that, what averment in dealing with the same, because these are very important. Somebody has, my lord, said before the court on affidavit.
Dealing with the Jishan Ali matter.
Jishan Ali. Yes, yes. Yes. My lord, kindly come to paragraph number 4. Paragraph number 4. Have you also got it, my lord?
Of the exception?
Yes. How he has dealt with that averment in the compliance report.
Yes.
Very necessary, since that chance he has taken to file an exception, when he has taken a chance to file exception, now how the exception he has, my lord, taken? And to what extent the exception? If something is left out, then that is admitted. Paragraph 4. Deny dispute 7 except what are matters of record. So what are the records he admit? I further said that the contender opposite party had sought to create a panic in the area by sending the police to my residence. Visit of the police at my residence was considered to be an abnormal situation. That means admitted the police gone there. If I have committed crime for which the police had come to my place, I say that in view of the successive dates of hearing fixed before the regional transport authority, the hearing was not held on the ground of absence of district magistrate and the board member. I refuse to accept the hearing notice scheduled to be held on 26/9, as the same was nothing but causing deliberate harassment to me. So here is an admission, Lordship, kindly consider. I refuse to accept the hearing notice.
Yes.
It appears that despite such hearing notice for holding hearing on 26/9 and 29/9, 29 September, no hearing was held in my absence. So he knew all these things. And the contender thought himself to be beyond the law. How? Just the opposite, something he says, contrary, and beyond the law and order of the Honorable Court. Compliance of the order of the Honorable Court dated 20th December 2022 depends upon his willingness, though the order dated 20th December is having a binding effect upon the contender. Contender opposite party cannot frustrate the said order. I beg to refer judgment, and these are then in the context, the last but one line in the context at the bottom, I say that contender opposite party intentionally, willfully, deliberately, consciously violated the said order of the Honorable Court. So, everything admitted. So, kindly consider one thing. Then contender opposite party failed and neglected to secure compliance of the order of the Honorable Court dated 20th December, even after getting extension of time to secure compliance of said. I say conduct of the contender shows and establish he has no respect. But these are all averment. But what are the facts? I can, this averment can be 5 paragraphs or 50 paragraphs. I can say many things. But the thing is this, that whether the whole thing is that within a very narrow compass, that whether opportunity of hearing was given or not. Here he admitted opportunity of hearing was given. I refused to accept because once I went there, I should not be present another. Any further. Do whatever you like. I shall file one after another contempt petition. So this is the, my lord, kindly consider. Is when this is the attitude, practically, my lord, the petitioner is the practically contemptor. Unless in a proceeding, he wants to, my lord, I think extend his support and help so that the order can be, my lord, be carried out. Then contempt of proceeding should be initiated against him. It is such a case. Do whatever you like. I shall not allow you to comply with the order because I would not be present. And the order, one after another day, order cannot be complied with because in my absence, if you pass the order, then I shall again take that point, that in my absence. And on the contrary, again, on the one hand, I shall not be present myself for the purpose so that the order can be carried out. Is it not a case that the contempt proceeding should be initiated against the petitioner himself?
That's
So kindly, my lord, this is all, my lord. I think, my lord, after this, considering my final compliance report, annexure, and his submission, admission in his exception, I think, lordship, kindly consider this and contempt proceeding, my humble submission, be dropped.
No case, Mr. Chamanta. I'm sorry.
Your lordship's order is dated 20th December 2022.
Yes.
That was not complied with. They got an extension of the compliance by an order date obtained from your lordship on 12th of September 2023. My lord, despite, my lord, at the first instance when I had served a notice, I attended, but nobody was there.
So after that, you chose not to attend.
My lord, your lordship created panic in the area. My lord, kindly see. My lord, your lordship, kindly see.
Heard learned counsels for the parties.
My lord, kindly consider, my lord.
I'm sorry.
My lord, why it is necessary?
Submission is required.
My lord, I am not on that. I'm not on that. Your lordship, kindly see. My lord, it is my application for contempt. My lord, your lordship's order has been violated intentionally, deliberately.
And the court.
And
And the contemptor has sufficiently explained his stand. So I don't think there is any
my lord,
problem.
I have only one paragraph, your lordship, kindly see. One paragraph,
Yes,
your lordship,
please
kindly
show
see.
me.
My lord, decision, your lordship, by the order dated 12th of September has extended.
Which paragraph are you showing, Mr. Sharma?
My lord, paragraph.
Please not repeat your submissions.
My lord, only, my lord. My lord, paragraph is a long paragraph, my lord. He has read paragraph 4 at the last
I've
portion.
seen that paragraph.
Last portion, your lordship, kindly comes.
Of the exception.
Paragraph 5.
Of the exception?
Page 5, yes, exception.
Yes. Page 5, yes.
My lord, I say that, my lord, after 10 lines,
Yes.
I say that decision of the authority as alleged in paragraph 9 is illegal and arbitrary, and the same cannot be alleged to be valid decision under the law. In advance as such decision having not been taken within the time limit fixed by the Honorable Court and within the extended time limit granted by the Honorable Court, and the contempt opposition instead of securing compliance had harassed the defendants like anything, and despite serving hearing notice or 18th September no hearing was there. But 18th of September no hearing was there. Even after receipt of the hearing notice.
And you chose not to appear on the subsequent dates. That is
Subsequent date.
Yes.
Whenever I visit, your lordship.
One occasion.
18th of July, I attended.
You are spending unnecessary time. There are a lot of other matters pending, so let me dictate the order. Heard learned counsels for the parties. It appears from the exception in the form of affidavit submitted on behalf of the applicant petitioner that notice of hearing was that the dates of hearing were intimated to the petitioner who refused to accept the notices of hearing and chose not to appear before the authority on several dates of hearing.
Now, that is after the expiry
Order
of time.
under contempt has been substantially complied with by the concerned authority by disposing of the application submitted by the petitioner by an order passed on 5th October 2023. Paragraph, in view of the above, the contempt application being CPA and such is disposed of. There shall, however, be no order as to cost as in certified website copy. Sorry, Mr. Shah.
Your Lordship, kindly make it clear, this order will not prevent the petitioner to challenge the decision on merit.
There is always,
Separate
that
cause
is
of-
always.
But this is
That liberty.
because of the delay.
That is a separate cause of action. You can always challenge.
Read petition have delay kiya hai.
Madam,
This
that
is only the order under contempt.
my lord.
Nothing beyond that.
Madam, the order, I took a chance. My like, matter is over.
Challenge the order.
My lord, I'm not on the merit, my lord. I'm saying only thing. What is the necessity of hearing? Law says, unless you hear the parties, you cannot reject it.
But if the party chooses not to appear before the
My lord,
authority,
that
what
be
will-
extended period after the extension.
maybe, but what does the law say then?
My lord, after your lordship twice extended.
Mr. Sharma, let me deal with the other matters.
Get.
Next, 539, same order.
The second matter also same.
Second, third.
Second, third matter also.
540,
540 malad.
all same orders?
Same.
All same order.
539.
Same order.
Bhabhi, very yes.
540.
Well, same order.
I have to-
540 te naam ta diye
The date is also the same.
540.
Karan
Same.
petitioner
Date
is
are,
alert.
yes. Date also same.
Petitioners are alert.
Same to same.
मतलब 538 Mr. Debroy appear, 539 I appear. And मतलब I think that
540
that slip has been given. Didi jo.
Next,
I 539
Number three.
up to 540.
up to 540.
540 আমি আছি 530 আমি আছি বলেন দিস ম্যাটার এন্টারিং অন বিহাফ
I have put private spot.
এই পল্টু দা
State, Mr. Debra,
আই এম filing one application 540
supplementary.
against the report
Oh, exception.
yes Mr. Devan appearing on behalf of the stand now so the matter was heard on several occasions today Manu Rank is raising the matter in a court format
541.
541 also actually against the report was submitted by the state and I submitted against the I'm placing the matter lots of manner now kindly see the page number 22 in the resolution
Give me a minute.
is it with opposition HON'BLE exception yes
Yes, the new route clashes with your extension.
yes prime cut segment well page number 22 well, transport department
I remember the facts.
yes right. Well, sir, but initially my lord I applied for extension of the permit
Yes, yes.
from my route is my Kolkata station to Rajarhat New Town. I made an application for extension of the road up to Satisara. And my existing road distance to the existing road is 90 kilometers. And after extension, the route will go from Rajarhat to Hatisara only 3 kilometers. 20.
Yes.
My application was placed before the RT board meeting held on 19th January 2023.
It is still pending.
But before that, one of the secretary General Authority Kolkata retained because our route was covered by two police commissioner. For this reason, their views are required.
So after obtaining the views of these both authorities, police authorities, my matter was placed. On the basis of that, can you see the resolution? Page number 41.
Yes.
And relevant portion, page number 43.
Yes.
Agenda number 6. Honorable police authorities, NOC was placed, that is recorded, and resolution, my lord. After agenda number 6 bottom resolution, we are able to discuss the matter and decided to take a decision after getting the field inquiry report from the official. This now, my lord, after this order, the secretary RTA, page number 48, requested ART of the MBI enforcement, page number 48, to make an inquiry to submit a report. And after getting the inquiry report, then final decision will be taken on the basis of that. But that was communicated to the ARQ or MBI by the secretary on 18th by memo number dated 20th February 2023. And I had so far my concern. So ARQ MBI received on 2nd March. But within 2 or 3 days gap, again this matter was placed before the RT board meeting, page number 49. That board meeting was held on 3rd March, only 2 days gap. And agenda number 5, page number 50. But that resolution, but
that is the mass petition.
Yes, it is a mass petition.
That is not your application.
No, because by keeping my application pending, this petition, when this application meant no date has been received, no date has been given yet. The mass petition received from the inhabitants of places, Hatisala to Harod, what it is, there is no sufficient transport services. They are facing the inconvenience. For this reason, they are requested by mass petition to grant a new permit. After that, they have also obtained the NOC from the police authorities. We have got also police authority. But we have obtained in my case, my lord, police, my lord, issued no objection on 13 November 2022 and 9 December 2030. Only one gap, the police authority also page number 50, 11 January and 19 January. Okay. On the basis of that, what is the resolution? They have decided to approve the proposed route, the formulation, with a freeze time 16th, and decided to maintain the place before the transport department for publication in the notification. This is the decision. After the decision, I raise the objection, page number 52, against the formulation of the route, because it is not the new route. Because of 19 kilometers from Kolkata station to Rajarhat, 19 kilometers, only extension new made. The mass petition was made for formation of the grant for new admit for Hatisala to Kolkata station. So, my lord, this is not the new route. Because so far, if the route is once formulated, or that is not necessary at the intermediate stage, not the new route, this is a part of the new route. So on this condition, on this ground, my lord, we made a representation, objection. That keeping my objection is pending, this objection was received on 4th April 2023. Keeping my objection pending, again the matter was placed before the board meeting held on 12th April 2023. And this time, my lord, this matter was placed on 12th, before the board meeting held on 12th April 2013, on the ground that they received an application from Vishnu Bangla Bus Services, page number 56, agent number 12. But earlier resolutions have been recorded up to 4 paragraphs, up to 3 paragraphs, paragraph 1, 2, and 3, earlier resolution. And 4th paragraph, thereafter Vishnu Bangla Bus Service applied for police time. When applied, no date has been fixed. For police tank of route number route as 24 police tank. In this regard, the Secretary Transport Department of West Bengal has been requested by memo number subjected 21st March 2023 to take appropriate steps towards application of government notification for the introduction of new stage carriage route from Hatisala to Kolkata station with a free strength of 24 for promotion of civil. To ratify earlier decision, now can see the resolution. After thread discussion, the RTA board approved the proposal for total free strength 24 to 24 of the state proposed route, new route, and also decided that out of 24 strength of permits will be reserved exclusively for electric surpluses, and also decided that for rest 20 distance preference should be given for electric buses. So I challenge these two resolutions in this writ petition. Resolution was dated on 3rd March as well as the 12th March, 12th April, because my application was pending. What is the resolution in my matter, in my application, which was held on 19th January 2023? That decision will be taken later on after getting the theoretical report from the official. You are that but is pending. We have my application is partly allowed. On this ground, I have challenged this. Or during the pendency of the petition, an application was made for additional party on behalf of the Vishwa Bangla bus services.
Yes.
Additional party. In the additional party, they have disclosed their identity. Who is Vishwa Bangla services? They are the intending operators interested in the field of passenger carriage transport. They have okay. Here is that they have disclosed that a mass petition was, but they have support of this mass petition. They have made an application for additional party. So this is a mass petition. In the mass petition, there is no reflection that this petition was made on behalf of the Bengal bus services. For that, there's mass petition. Only last paragraph, page number 12.
Page number 12.
The new bus. This is the mass petition. And also page number 22. Resolution 3rd March. I have already annexed my petition. I have already. Please, with your lordship. Page number 22. The application for additional party. Page number 22.
Yes, yes.
I have already annexed it. I have also placed before your lordship. And Annex 6, page number 25. Resolution of 12 April 2023. Page number 25. I have also placed. Malwa has got
25.
20.
Yes.
I have also placed in. I have also annexed in my writ petition. I placed this resolution, Malwa. Just I placed, Malwa.
Page 25 of the writ petition.
No, the additional part. Application for additional part. On behalf of Vishwa Bangla bus service.
This is the same resolution.
Same resolution. So I have placed. So that's what is also same resolution was placed. Now page number 28. Vishwa Bangla bus services made a representation to the Principal Secretary on 11th May 2003. That representation was annexed in this petition. But when Vishwa Bangla bus services made the representation for enhancement of the police strength, but that has not been disclosed and that has been annexed also. Now, on the basis of that representation, that is on 11th May 2023, and keeping our matter pending because our application, head of my application has not been finalized. Now, can you see the page number 30? On 25th May 2023, a notification was issued. This representation was put on 18th May. This notification was issued for formulation last paragraph. Now, therefore, the government has been pleased to formulate. Because our objection against the formulation that has not been considered. The violation of natural justice. Violation because in the last occasion, my lord also held my lord that violation of natural justice, and the notification of the first paragraph, first line. The Regional Transport Authority Kolkata received a proposal dated 16th March 2023. But this application or the presentation of the Vishwa Bangla has not been annexed. I have not seen what is the reason. intention of this, but so I have challenged this resolution in my lord, that was place. I've also annexed in my supplementary evidence. Can you see my supplementary evidence? Supplementary evidence. Supplementary evidence. But in the supplementary evidence, I have enclosed the value notification. This notification was issued on 25 May 2023. Madam has got it. Supplementary evidence.
There is one issue that needs to be taken into account. Vishwabangla's application at page 28 of the
Yes.
application.
Yes, yes, application already
That was received by the authority on 11th May 2023. But Vishwabangla's matter was dealt with by the authority prior to that.
Right. So I have also correct in my supplementary evidence. I have challenged on the one ground that this notification was issued on 25th May 2023 and matter was sub judice. For this meeting, another board meeting was held on. Another board meeting was held on 20th July, page number 10. I had placed my lord during at the time of hearing. Then my lord directed me to file supplementary review and including these documents. Place page number 10. Annexure P11
of the supplementary evidence.
Supplementary. My supplementary it is affirmed on. It is affirmed on 22nd day of September 2020.
Yes. Page?
Page number 10. Page number 10. Supplementary. Page number 10.
This is a subsequent resolution.
Supplementary evidence on behalf of the petitioner. And on relevant portion, page number 11, at the bottom.
Yes.
At the bottom, notification was issued, but decision was taken. The RTA board considered the matter and decided to act, not to act upon it for the time being, as the matter is sub judice. Because matter is sub judice, because we have taken the point, our objection was not considered before that, and on my pending the other board meeting. You are not supplementary. All. Number page. Now kindly see page number 30. Now this decision was taken by the RT board that no decision will be taken till the disposal of the information on the basis of its notification. Notification was 3 times was extended.
Page 13.
Page number 13.
Of the subsequent
Page 13.
Supplementary evidence.
Supplementary. But decision was taken by the RT board on 28th July 2023. Well, what is the functions of the secretary? This notice was issued by the secretary on 23rd August 2023, inviting application from the intending operators for submitting the application for grant to farm in terms of the notification. But what is the resolution? We put that 28th by July that no further steps will be taken on the basis of that notification for time being as the matter is submitted.
They indicated that that matter is not sub judice. Only your application matter is sub judice.
Yes,
so they can take a decision on that.
Yes.
The new route matter is not sub judice.
No.
That's all your submission.
No, I agree. Therefore, my lord, a report was submitted. A report was submitted. A report was submitted by the state government. Against this report, my lord, the report, what is the report? That, my lord, and all the 3 resolutions annexed in the state report, but this report was submitted.
Yes.
By
I am appealing for the private respondent, added respondent. So many facts are involved there. I want to file an affidavit dealing with all these facts because there are certain allegations against my client who are in receipt of the resolution on 3rd March. Their route has been approved.
several allegations have been made. I want to deal all these things.
There are no allegations against your client as such.
Resolution.
Point is keeping his application pending.
Resolution. I am the beneficiary of this resolution.
Yes.
If the resolution goes, my grant will go, or the route will go, whatever it may be.
Doctor.
There are certain
Affidavit
allegations.
in opposition is not required in this matter, sir.
Because one
Several occasions, my lord,
two,
never paid for
three
time.
documents.
Filing
Two, three documents, because route is a notified route, 71-3A, this K1 also,
Yes, fleet strength is 24, yes.
Princeton has been fixed. And whether the route which has been notified by, established by the state government and notified by the state government, fixing the fleet strength, can that route be extended by the RTA or SK on the application of the existing operator?
Decision needs to be taken by the RTA.
No doubt, no doubt.
And if
But there is a already decision taken by the state government on this aspect. That is not on record. Oh, that is on record. That is no, not this.
On several occasions, routes have been extended. So this is not a new case. On several earlier occasions, routes have been extended by this government. So this is not a very new case.
I was also impression there is no requirement. But recently, while dealing with one of my matter, that matter has not yet before your lordship. That matter is pending. Before the vacation, it has been taken. A notification has been issued by the state government, indicating that the routes. No, let Mr. Khan complete. I shall show that notification to you.
Not spend more time on this. If you want to come back with an affidavit, if you want to come back with an affidavit, it will take some time, and the resolutions have to be stayed.
Yes,
Resolutions cannot continue.
Yes.
Resolution has not
already, my lord, there is already decision, my lord. So no steps has been taken.
No, but
No steps has been taken due to sub judice of the matter.
if it is so, after the resolution, under what capacity the secretary by the corporation, what action has been taken against the
So
secretary?
the petitioner's application is
That's
pending.
not the department will go on.
Keeping that pending, you have issued a new route.
No, there is no bar. There is no bar.
There is no bar.
And my lord, one thing was, this is not the identical route. This is not identical route. It is a portion of the route. This is not a bar. Under the act, this is not a bar.
Was there any bar in disposing of his application?
So that is subsequent direct disposal of his application.
After obtaining NOC from the, so don't you smell something wrong in this?
No. There is no smell, no, nothing like that. Only facility to the commuters at large. Commuters at large. There is a number of mass petition is there. Is a malad that is.
He wants to, Mr. Chatterjee wants to come back with affidavits. Let it be heard on affidavits. In the meantime, all the three resolutions will be stayed. You cannot proceed with the resolution, sir.
No, I cannot.
No. The resolution has not yet been acted upon.
Not yet
Not only this, my lord,
when I appeared any matter, my lord, I specifically directed the authority not to take any further step.
No.
Till the matter is
action
till
taken.
the hearing has completed. This is my instruction, properly instruction.
Action taken on the basis of that notification.
but in the report it is silent. What is the fact? My application, nothing discussed in the report.
No, it has been discussed. It has been discussed. Mr. Khan has skipped. It has been discussed in the report of Mr. Debray, which has not been opposed by Mr. Khan.
What has been discussed? Let me
Yes,
just see.
your lordship.
With regard
Report,
to the
report.
application of
In
Mr.
the
Khan.
report of Mr. Debray.
No, last, this is the report on behalf of the respondent number so.
Yes, your lordship kindly come to
Statement with regard to Mr. Khan's application.
your lordship.
Respondent number 225.
Your lordship kindly come to the report of Mr. Debray.
Yes.
First of all, your lordship kindly come to paragraph 17.
Only discuss the decision was taken.
No. Paragraph 17.
But what is the fact of my application?
Down.
And what is the without consent
In the
objection?
meantime, the application for extension of route K1 was taken up for consideration during the board meeting held on 28 July 2023, where RTA board considered the report of the concerned motor vehicles inspector, environment, the enforcement, public vehicles department, wherefrom it transpires that the operator of route number K1 are already plying their vehicles illegally up to Hatisala without obtaining any approval permission from the authority. It was also observed that the operators of the said route have also approached the Honorable Court. They filing present writ petition challenging the decision of creating new route, allegedly delaying in considering the application for extension. Since the matter is sub judice before this court, the board has decided not to act upon the for the time being.
This is affidavit.
This is
On
the
affidavit, they
Now
are
the Lordship can see the resolution itself.
they are flying illegally.
Same thing is state criminal.
Same thing. No, this is the report of the MBI. And that has not been denied.
But what is
Now,
my application that is signed as the
No. They are
Come back on affidavits.
they are illegally flying.
They are illegally flying.
They are illegal.
And your Lordship
They
can see,
they
as
should be
per
stopped.
Prohab's judgment.
They should be stopped flying.
This is
They are
Illegally.
have taken any steps.
what is
As the matter is still pending before your lordship, that is why you are not taking any step.
Matter with regard to illegal flying is not pending.
Then we are taking from today we are taking steps.
Now, my lord, another aspect of the matter. In the writ petition, Mr. Khan's clear affirmation is this: if this new route comes, they will suffer huge financial loss. And in spite of that, they file writ petition. In Prohab's judgment, which is a full bench judgment, categorically said that an existing operator has no right to challenge the decision of an authority for creating a new route in respect of financial loss.
Even if there is a clash, I don't.
Even if there is a clash.
I need to.
No, even if there is a
Portion
clash.
of clashing always there.
Even if-
It is some portion clashing always there.
Want to come back on affidavits, you can.
Fine.
For learned counsels for the parties. And Mr. Devra assures that the resolution.
This is the only oath. Only oath there is a
The applications has been invited, that has been submitted before the writ petition has come up for hearing. Before that.
Now I have
After that,
specifically
no decision-
stated.
No decision has
That
been
is why in the report it is transferred from the report.
I was minded to give a direction upon the authority to dispose of the representation. as
That
well.
is better, man. That is they can
Application
dispose
as
of the matter.
Your Lordship can do it.
Lordship
It's
can
no problem.
dispose of the matter.
Mr. Khan is doing elaborate submission.
That is
That's
not
why
required.
It's not required. There are two parts.
His application be considered in
On
accordance
the
with
entire
law.
facts of the case.
No, his application will considered in accordance with law. Well, that is my
Presentation.
on the
Yes.
basis of report.
No. His representation
Transport
relating
Direction
extension
dated
of route
19th
has to be
January.
decided by the transport department,
Well,
rightly or wrongly.
As per resolution.
If it is wrong,
per
he can
resolution
come.
19th January 2023.
he cannot prevent the other operator.
So shall I dispose of the repetition?
Yes, Lordship can dispose of.
Before giving effect to the subsequent resolutions, let his application be disposed.
ঠিক আছে থাক Yes, my lord. Lordship can dispose.
Yes?
Yes. হ্যাঁ ফালতু করে রেখে লাভ নেই।
Well, after setting aside all these.
No setting, no question of setting aside.
Not setting
No
aside.
setting aside.
First, your application will be disposed
Yes,
of,
my
then the
তোমার তো
resolution.
purpose start হয়েছে।
first my application will be considered.
Yes. Then your others application.
But learned counsels for the parties. তার আগে করুন।
আমরা চুপিয়ে দেওয়া তো ব্যাপার।
The grievance of the petitioner is that. No, এটা কেটে দিন। The petitioner applied for
ফালতু চন্ডি ধরিয়ে দিয়েছে আমাদেরকে এনগেজমেন্ট
extension of route.
কি দরকার কোনো মারামারি করবে আমরা কেন
Petitioners being holders of stage carriage permits in the route Kolkata station to New Town, Rajarhat, applied for extension of route up to Hatishala. Stop. Upon obtaining no objection from the police authorities, the RTA board, by a resolution taken on 19 January 2023, decided to take a decision after getting field inquiry report from the office end. Stop. End. Thereafter, a mass petition from the inhabitants of some villages and an application from the Vishwa Bangla bus service were received by the authority for introduction of a new stage carriage permit from Hatishala to Kolkata station, the new route. From Hatishala to Kolkata station, which were approved by the board in a resolution taken on 3rd March 2023. In resolutions taken on 3rd March 2023 and 12th April 2023 respectively. Stop. By a subsequent resolution taken on July 2023, the board held that the application filed by the petitioner for extension of route up to Hatishala was not acted upon since the matter was sub judice. Stop. Paragraph. The primary grievance of the petitioner is that without disposing of the application filed by him for extension of route, the board has taken steps for introduction of the new route, a portion of which overlaps the petitioner's route. Stop. Paragraph. It is not in dispute that the applications made by the villagers as well as the Vishwa Bangla bus service were subsequent to that of the petitioner's application. By resolution taken on the first resolution page 41. By resolution taken on 19th January 2023, the board decided to take decision after getting field inquiry report from the office end. It is expected that such field inquiry report has reached the board by now. Paragraph. In view of the above, this court is inclined to hold that the application filed by the petitioner petitioners be considered and disposed of by the board before giving effect to the resolutions taken before giving effect to the subsequent resolutions dated 3rd March 2023, 12th April 2023 and 28th July 2023. Stop, respectively. The paragraph, the writ petition is accordingly disposed of, directing the second respondent to consider and dispose of the application filed by the petitioner for extension of route within
1 month attribute হয়ে যাবে
6 weeks. 6 weeks. 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Stop. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, the second respondent shall be at liberty to give effect to the subsequent resolutions dated 3rd date the 11th after disposal of the application filed by the petitioner.
Communication will be
7 days. Huh? Disposed of which application?
I'm sorry, my lord, to mention
March implies, my lord.
one extreme urgent matter of civil division application, item number 593, my lord.
Yes.
My lord, appreciating the urgency, has directed the matter to be listed, my lord. This matter,
Sir, it is your resolution, not mine.
my lord, item number 593, my lord, matter is fixed for final argument, my lord, in the coming week, my lord.
Argument takes some time. Why are you so apprehensive?
My lord, apprehensive is that, my lord, if certain title documents unstamped, unregistered, were being exhibited by the trial court. If matter is not taken up by your lordship, my lord, prior to that it will become infructuous. When
is the next date?
The next date is on 28th, my lord.
28. Let it appear on Monday.
My lord, I am sorry to mention, my lord, because the matter which is appeared.
Not the mentioning time, madam. Please mention tomorrow.
Item number 593.
593 to tomorrow. Me today, sir, but you have taken a resolution not to call.
My lord, very urgent matter. The matter is appearing on lower court tomorrow only, and the party, petition that parties are will not added party miscellaneous appeal and title suit. So kindly give liberty to mention, my lord.
Come back tomorrow morning. Come back at 10:30. Even if you mention today, it will be the same, isn't it? Mention tomorrow morning, 10:30.
Okay.